Morning, good morning, amazing. Lawnard, it's Thursday, it's April 16th. We're live, we've got much to talk about. Who knows if we're gonna have more things that we need to talk about? Because there might be, you never know. We've had some new docketed items that have caught me, as we're streaming, after we're streaming, all the things. So who knows? But here's what we intend to cover today. And then if we have bonuses, we have bonuses. Today, we're going to be covering the prosecution's response to Kouri Richins asking for a new sentencing date. That came in after stream yesterday. And when I went to the docket to just kind of do my checks, because we know that the prosecution's going to respond, I was like, haha. So I was very excited to see that yesterday. Some of you saw that I shared that in the app. If you don't have the app, there is information that you are missing. If you don't have the app, you are 100% missing when things happen after stream and I send out an app notification and I'm like, hey, I made a really quick, YouTube short to explain it to you. I put those up on YouTube. Those are generally unlisted. They're for the app. So if you have the app, you will get that notification first. And that's what we did yesterday. So I think a lot of you saw that on the app yesterday. And then we also are getting back to the Karen Reed coverage that we were going to do yesterday, and we kind of skipped things around and got all of the Taylor Frankie Paul stuff covered yesterday, answered the questions that I was getting the most frequently, and we're circling back to still new stuff in the Karen Reed civil case, but not as new as what was going on yesterday. So today we are going to cover what's going on in Utah. I'll double check and see if there is any response from the defense. However, we do know that Kathy Nestor particularly is involved in another high profile trial that has a pretty substantial hearing tomorrow. So tomorrow regarding cameras in the courtroom and stuff. So that is the goal for tomorrow. That is what's happening there tomorrow. So let's get into all of the things, shall we? You guys ready? All right. Let me know where you're coming in from and what you're drinking. And I've got coffee. I've got hot coffee. We needed hot coffee today. And we're going to go ahead and pull up the things and we're going to go for it. Y'all ready? All right. Cheers. Let's roll the intro and let's get into it. Again, let me know what you're coming in from, what you're drinking. We're going to roll the intro. Let's go. That again, Emily, do we put it in the right place? I was listening to Ryan Hall, y'all, last night, not through my in-ears. And that's why the audio's in the wrong spot. It'll be better this time.
Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time, so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court.
All right, y'all. Good to see you. Good to see you coming in. We will do a brief road so far. I think that will be helpful. Some of you had some YouTube glitches. It's not your internet. It's probably on my end. Things are spicy, though my internet says it is absolutely fine and dandy. So I don't know what that is about. We had some of those issues yesterday. I will say that we record is separate than just streaming to YouTube. So when we do have glitches, A, it's frustrating. I know it's frustrating, but B, when the case briefs go up, we still have the case briefs up that don't run into those problems. So if it ever is an issue where we're like, oh my God, what's happening? The case briefs will always be up for you the next day. So those are always an option. That's on the Emily Show channel. Those are also on your podcasting app. So those go up there as well. So if you're ever worried about it, those are on your favorite podcasting app. Just pick one, unless it's YouTube. They're on YouTube too. And we send them out on the, my necklace is twisted. We send them out on the app as well so that you get an app notification and you don't have to worry about what channel you're on. You just push it through and they're just like, yay, there we are. We're where we need to be. So we try to make it easy every single time. Shall we do a bit of a road so far? I think that we should do a bit of a road so far because some of you are just like, what are we talking about today? We'll do a road so far for Kouri Richins, and then we'll do a road so far for the Karen Reed wrongful death case. I think that'll make, did I say Karen Richins? Kouri Richins. Today, if anyone puts KR in the chat, I am not going to know whom we're talking about because we keep putting, Emily, you decide what we talk about in a given day. I know. I keep putting both of the KR cases on the same day. It's very confusing. It gets confusing, and that's just not helpful. That's not helpful at all. So when we put both of the KR cases on one day, we just know, I don't know who we're talking about. We could just put Utah or Massachusetts. Either way, we will do a road so far for Kouri, and then we'll do a road so far for Karen, and then we'll answer questions, and maybe should we just peep the docket early? I mean, it's a reasonable time in Utah, so it's not like we are ever streaming so early that we are not within the reasonable work hours of just about everywhere. So we can do that too. Let me just grab it. Why not? Let's do that we'll do that before we roll, and we'll do that after. How's that sound? Just, do I expect that the defense will have filed anything today? No. Again, Kathy Nestor has a hearing about cameras in the courtroom and stuff in the Robinson case tomorrow. I don't know if she will respond, but that's why she has a firm partner. That's why there's Kathy Lewis and Ramos. Like, somebody else could file it and respond in theory. I don't know if they will, but they could. All right, let's take a quick peek. And yes, we have to do a CAPTCHA every single time. It's really annoying. It always takes me a minute. I hate them. I understand the CAPTCHAs, but also, there was a story that I saw recently about one of the chat AI models that couldn't do CAPTCHAs and then was like paying people on Fiverr to do CAPTCHAs for them. I was like, oh, okay. So that's where we're at. This docket is just taking a million years to pull up. So we'll come back after we do a road so far. So where are we with sentencing? We all watched the 3-hour verdict in the Kouri Richins case in Utah together. She was convicted of aggravated murder. That means that she is facing either life without the possibility of parole or 25 to life. And her defense team filed a motion to continue sentencing. That motion was filed on the docket it was filed April 13th. I think it hit the docket after that. It might have hit the docket Monday, like late in the day on Monday, because we covered it Tuesday. So they filed that on Monday, which is exactly a month before the sentencing that's supposed to take place on May 13th, which happens, I think, by coincidence or the universe having a sense of humor to also be the victim in this case, Eric Richins' birthday. And when that sentencing date was set, we talked about it that day. But we remember watching the sentencing date get set where the judge is like, I've got this day or this day. And then the defense team did a full huddle at the table and we're like, we are available that day. The court said, if you need more time, let us know. And the defense was like, yeah, we'll let you know if we need more time. Well, on Monday, the defense came in and said, hey, not only do we need more time, we want a different day. Can we kick this out an additional month till June? Kathy Nestor cited several things in requesting that continuance. 1, she needed more time to prepare. 2, she had a recent death in the family. 3, that she mentioned that Ramos was going to be in trial, and because Ramos was going to be in trial, then they needed to kick it over. So there were a number of reasons that they wanted to continue the sentencing. And I was like, or is it because it's on his birthday? Like, which one? Which one is it? So the prosecution responded after stream. Well, I saw it after stream yesterday. I mean, I guess it could have hit the docket before stream. I didn't check the docket during stream, but after stream, as I was, doing my kind of sweep of any updates before I get into working on other things, the prosecution had filed their response. Well, their objection. So we are going to go through that objection. There is just a brief part of it that is redacted, but it is on the docket. So we're going to see what Mr. Bloodworth had to say. No spoilers to those of you who have already seen me cover this in a very brief way, because there's more. And as we're looking at this docket, I don't see anything filed today. Then again, I will keep an eye on it and we'll see if anything gets filed later on. But I would expect perhaps we see the defense file that in, I don't know, Monday, Tuesday, next week. I don't know if they'll file that this week because of the things they have going on in other cases. All right, let's go to this docketed item filed yesterday because the state is objecting to Kouri Richins getting a continuance, and I don't disagree with them. However, if the defense says we need more time to prepare, the court might say you have a month. Like you still have a month. And the sentencing was set 2 months out from the conviction. She was convicted March 16th? That is a substantial amount of time. So we'll see. But often when the defense says we need more time, the court will probably give it to them. Then again, 2 months to prepare for sentencing is a substantial amount of time. It's not, in a lot of the cases, everybody's like, yeah, we can do it now. We'll do it tomorrow, whatever. 2 months is a substantial amount of time. And if there was, and, we have family tragedies that come up, but if there was a family tragedy that came up, it's still a month out. And you had a month before. So, and it seems that Nestor is still prepared to go forward with the hearing tomorrow. So I think it's enough time. However, if the judge needs a full day for sentencing and does not have a full day on May 13th, that may be a reason to move the date. And maybe the judge will split the difference and move it to later on in May. I guess we'll just have to wait and see. Oh, God. It's gonna be May. It's not too early. It's mid-April. It's not too early. It's not. I feel like the entire year has disappeared. And, but it definitely, especially if you live in the Midwest or the South, it definitely feels like spring this week. Spring stress. It feels like spring this week, but it's basically May at this point. So let's take a look at the prosecution's sass and response. No, it's well played sass, I think. It's my opinion. Where is it? There we go.
That's my opinion!
It's my opinion. Preferred disposition and grounds. The state of Utah requests that the court deny the defendant's motion to continue sentencing. For 3 years, Eric Richins' family has painfully and patiently stood by as the defense has manufactured one reason after another to delay this proceeding. There is no good cause for them to suffer further delay. The time has come for the court to sentence Kouri Richins.
Liar!
Wait, no, wrong one. That one. Damn it, Freud took over the soundboard and doesn't believe the defense allegations here. The soundboard was just like, no, liar. I was looking for the gavel. I'm going to have to change the color of the other one so it's not the same color as the gavel, because obviously that continues to confuse me. However, I'm always glad for a happy accident on the soundboard. I don't disagree with the prosecution that the time has come for the court to sentence Kouri Richins. I don't disagree. And this case was getting ready to go to trial when the defense brought all the change of venue stuff. And then 2 different things went up to the Court of Appeal, something about the jury selection and the change of venue. So multiple things went up to the Court of Appeal and back. This case had some substantial delays. It absolutely did. Statement of facts. Just the facts. And the coffee. We've got to finish the coffee. We're just coffee, court filings, and Bloodworth sass. It's all good. It's all good. Statement of facts. Throughout this proceeding, the state has deferred to defense counsel on scheduling every single time without exception. It's true. That is true. The prosecution has been incredibly accommodating to the defense's schedule. On March 16th, immediately after the guilty verdict, defense counsel conferred and confirmed their availability for sentencing on May 13th, 2026. The following day, on March 17th, 2026, the defendant's aunt asked the defendant if the sentencing was scheduled on Eric Richins' birthday. I mean, we all knew it was scheduled on his birthday. The defendant answered that it was, quote, as of now, but that she, quote, told Kathy Nestor to schedule it for the end of May, and that Miss Nestor, quote, said that she would. Girl, did you forget? Also, to be fair, she had just been convicted of aggravated murder. She might not have been processing the information when they were picking the sentencing date. Her attorneys probably did not clock it. I don't think that the court clocked it. I think that the family, I'm sure, sat there and was like, yep, absolutely. But all the defense attorneys agreed. They all talked about their schedule and said, yes, we can do it that day. And Kouri, if she didn't say anything, it might be that she completely forgot. It might be that she was still a little bit stunned that she had actually been convicted and was still thinking, what is happening? To give grace, fair. However, it doesn't change anything, really, that it happens to be on his birthday. I'm sure the family feels that it is a nod to the things that happened after his death, especially as we look back, and this is me just speculating, but especially as we look back on the things that happened after Eric passed. After Eric was murdered. And we got to switch to post-conviction language in my brain. But it doesn't change what the court will say. It doesn't sway the court one way or the other. So there is a redacted segment. Okay. They are allowed to redact things that are private and or privileged. It goes on to say, we need more coffee for this. According to Exchange, and that's their docketing court program, Alex Ramos's trial the week of May 11th was set on March 24th. 8 days after this May 13th sentencing was set. The trial is a second place setting behind a 2021 case, and his client is out of custody. I'm going to translate that from lawyer to law nerd. They go on to talk about who the co-counsel is. Here's the thing. First of all, a second place trial is probably going to trail a couple of days or get pushed over. An out of custody defendant does not have to start trial that day the same way an in custody defendant does. If it is an older case, the older case will go first. And trying to use but counsel has a trial when that was set second is just BS. It's BS. And that's why it's being pointed out. It's like, no. This was scheduled first. If you scheduled that, you probably scheduled it knowing that it was going to trail, because you can have a trial trail behind. We don't know what day of what it is. It might be a 0 of 10 where it's going to trail for 9 more days before it even starts. But also, he is like third counsel. So if they don't need it, then it's if he starts trial, does he have to be there at sentencing? And he picked this trial date knowing about the sentencing date. And it's an out of custody defendant. So it's not like he's within a statutory time where the court's like, you have to be here. And even if it was, you don't need all 3 counsels for sentencing. So interesting that Nestor is using Ramos's trial to try to add, weights on that side of the scale for a continuance. So if you're looking at the scale being status quo, they're trying to push the scale in favor of continuance. And they're using Ramos's trial as additional fuel or weight to do that. However, if Ramos had made this argument, the court would just be like, counsel, really? You said that one afterwards. Argument. Quote, the presumption of innocence falls with a guilty verdict, not a final judgment. And then they cite the case law for that. Eric Richins' family and state need no longer defer to defendants' scheduling preferences. I said preference is weird, but whatever. Rule 22 contemplates sentencing within 45 days of verdict. The 53 days currently scheduled provides sufficient time for 3 defense counsel to prepare mitigation evidence, notwithstanding Ms. Nestor's loss of a family member. That is the reality. That is just the reality of things. They've had 2 months to prepare. And they would have talked about this prior to trial. Eric Richins' family has a statutory right to a speedy disposition of the entire criminal justice process. They have stoically endured 3 years of defense delay and continuance that has exacted an enormous toll, and then there is more of that is redacted. I don't doubt that it has. There are rights to the victim's family, though they are substantially less than to the defendant, but they still have rights there. And we might now, after sentencing, be at the time where if the court says, I can give you a full day, we're not going to go out a full month. We're going to, go to another available day in May. I think the court also said he was free the 25th, 26th, 27th, whatever. So the court might split this and continue it until the court has an open full day, because that's a valid concern. We need enough time to do this hearing. That's fair, but not go all the way out another month till June. Okay. I agree. A lot of you were talking about how woefully short your bereavement leave is through work, which I take substantial issue with. I think they are all too short. Also, I think that it shouldn't have to be linear because grief is not linear. But either way, it is what it is. And a lot of lawyers, the court's like, okay, well, if you need time off for a funeral, you can have time off for the funeral. Do you need a full day or like a half day? Can you do it in a half day? It can be tough. And different offices are different, but the courts are like, I understand that life happens, but we got to keep going. And the more attorneys you deal with, the more people's lives you're dealing with. You just have to keep going. It's hard. But it is hard. But you have to keep going. So it's not my preference. Then again, we don't get to live in the world according to EDB, but one day maybe. we will immediately ban harsh overhead lighting. That'll be one of the first things to go, because if we're all a little bit calmer, I think we can work through the other stuff. We need to get rid of some of those things that make us just wild. All right. Emily, spoken like somebody who's very light sensitive. Yes. If I don't have a migraine, I can get much more accomplished. It goes on to say that indigent defendant Kouri Richins was appointed counsel through the Indigent Defense Fund. She did not have assets to procure legal counsel. Indigent defendants have the right to court-appointed counsel if they face any possibility of the deprivation of liberty. She has been appointed 3. It goes on to say the right to 2 or more attorneys applies only in capital cases. This is a non-capital case. And what he means by non-capital case is that even though this was an aggravated murder, the state was not pursuing capital punishment, ergo not a capital case, because that punishment's not on the table. And so because that punishment's not on the table, this is not a capital case. She still got the entire law firm of Nestor Lewis. Well, maybe not. They might have more lawyers. That's being hyperbolic. And Ramos, paid for by Summit County. Over $1 million. So, B2 is like, oh, she isn't rich. Yes, as it turns out, B2, the negative millions in assets doesn't count. She's only a rich girl when it benefits her. When she's going to get court-appointed counsel, no longer. But I also, based on everything we've seen, I don't think she had the funds. I don't know if Summit County had the funds to pay millions, over $1 million, in contract to the defense attorneys. It's a lot of money. This case absolutely cost Summit County a substantial amount of money. So, going on, they say that to the extent the court credits Mr. Ramos's unavailability, it's immaterial. Your Honor, who cares? If Ramos isn't there, it's going to be fine. Like Ramos wanting to be there or Kouri wanting him to be there isn't enough. She has other counsel. To the extent the court credits Mr. Ramos's unavailability, it is immaterial. Sentencing can proceed with the defendant's 2 remaining counsel. A continuance would have problematic ripple effects. I'm going to try to zoom this in just a little bit. The deadline for post-trial motions is pinned to the date of sentencing. This is a fantastic argument. It's a fantastic argument. The deadline for post-trial motions is pinned to the date of sentencing. Eric Richins' family members and members of the prosecution team have already scheduled time away based upon a calculation of when post-trial litigation would conclude. We picked a sentencing date. We looked at our calendars after this extensive trial and went, okay, we will be clear of these motions by this date. That means we will be clear. A month-long continuance will needlessly disrupt this scheduling. Fair. The motion is untimely. You know how I feel about an untimely motion. Untimely! I've told that story a few times. Some of you may remember, some of you may not. Maybe we'll tell it again. Untimely. This motion is untimely in that defense counsel should have filed it by March 17th when the candid basis for the continuation request came to their attention. One too many mornings. He's objecting. Yes, he's objecting on the grounds of takesies v. backsies. This is exactly correct. The entire motion has been based on the enduring and beloved precedents of takesies v. backsies. And in this case, takesies v. backsies says no takesies, backsies. This has been scheduled for a month. Like we've gotten beyond the statute of limitations under takesies v. backsies. Like you are a month away from sentencing. But the candid reason for the continuance became apparent on the 17th, the day after sentencing, when Kouri was talking to her aunt saying, I asked Miss Nestor, remember what's in that jail call that we have heard about here? On the 17th, Kouri already says that she told Nestor to reschedule it for the end of May, and Nestor said she would. The client asked for the sentencing to be moved on March 17th or on March 16th, but she told her aunt about it on March 17th. So why wasn't the motion filed within a few days of that? Why are we waiting? It's a great question. It's a great point. So that's where we're at. Takesies v. backsies. No takesies v. backsies. It goes on to say that Eric Richins' family and the state are available all day on May 13th, should sentencing require a full day. and the week of June 15th. So there is also an acknowledgement that if the court does decide to continue it, that there is some availability there. And the prosecution is asking the court to deny the motion. It's hard when the defense asks for more time. The prosecution makes an excellent point. You've had well more than 45 days for sentencing. And even though there is a family tragedy, there is still a month left for sentencing. So what could possibly take another month to prepare for sentencing that they wouldn't have already prepared for trial? I don't disagree. I think the court might still give them more time. Maybe not a full month. I would love the court to say, no, I've got a full day available on the 13th. We agreed to it. You waited more than a month. It puts the prosecution and the victim's family at disadvantage. We are going to be getting into the summer. That's going to start impeding summer travel and summer plans. And the family also has rights. And the speedy sentencing is fair. So, I'm curious to see what the defense says. And the defense is, my guess would be something along the lines of, but Your Honor, we need more time. We need time to adequately prepare. This is a significant sentencing. And the court might actually just hold an informal conference with counsel and be like, what dates are you guys available? We're not going all the way out till June. Let's figure out what dates you're available. Because it's a lot of people to move. Or the court might say, which I would hope, but I don't know if that's realistic. The court might say, no, you agreed on this. You had enough time, and you waited a month after your client said, let's continue this before you filed it with the court. Why wait? Why wait till a month out? It would be easier for everyone to reschedule. Well, maybe because there isn't good cause when there's still 2 months away. Because what would the court say? You still have time. Like, just get it done. You've got time. We're not moving the deadline. So just handle it. A number of you asked a question in the chat. I'm going to pull something up real quick and see if I can verify that. Let's see. I'm going to see if I can pull something up. Give me 1 second while I'm looking for that, because I think I can verify what you are asking me about real quick, because I have the documents. Let's see. There is the prenup. Yes, chat, to confirm. I just wanted to confirm. June 15th is indeed their wedding anniversary. Or, well, would have been their wedding anniversary. Yeah, I didn't remember that one. And then thank you, Borker K, for pointing that out, because I wanted to double check it, because that date didn't stand out in my mind. Kouri Richins' 4/20 birthday, Eric Richins' May 13th birthday, but the June 15th wedding anniversary, I had forgotten about. Yeah, but in the prenuptial agreement, So, I guess if it does get continued, then it's getting continued. If it gets continued onto June 15th, then that's where it's getting continued on. And then here, I closed that. Let me pull that up. Bloodworth didn't ask for the 15th. The defense did. The defense in their motion. Let's pull up the defense's motion real quick. And I close this prenup and let me grab it. But the defense, I have too many tabs open. I'm going to take a look at the defense's filing first. But the defense asked for the week of June 15th. So the defense asked for that week. They did not ask for June 15th specifically, but they asked for some time that week. But now I'm kicking myself for closing the prenup. Let me just pull it back up. That took me a minute, and I've closed out of my tabs but it should be, let's see. I am trying to find it. Where did I put it? And what tab did I close? There are too many in this case, but the prenup was attached to a whole bunch of things, and I think that's where I grabbed it from. I'm going to have to just Control F to find it again. I'll pull it up. But yes, the wedding anniversary on June 15th from their backyard wedding, which we talked about when we were looking at the estate cases, because Kouri was trying to pin that time to when she started living at the residence, which we talked a lot about when we just went over the estate cases. So thank you, chat, for your incredible memory. This is why chat continues to be undefeated. Because if there is something I forget, which absolutely happens, y'all won't. And I love it. So we'll see. What would you rather, Kouri? The wedding anniversary date? The birthday? Because it's all in the files. AR asked, are pin chats on the bottom now? Yeah, no one asked for this, but yeah. I thought it was a glitch. Someone decided to change it. I'm gonna be getting to have a conversation with someone's at YouTube next week. This is the first thing I'm going to ask them about. Let me know. It is rolling out across channels. Do you like it pinned at the bottom or not? You let me know what you think, because I have my own opinions on that. Yeah, I'm not going to shade them for dating it 2025 because I just did a reel about this and dated it wrong. I do it all the time, but a lot of you hate it. A lot of you hate it. For those of you that still have it pinned at the top, I love that for you. Okay, all of you hate it pinned at the bottom. Good, I'm going to point them directly to this chat. So for some of you who have it pinned at the top, it just hasn't updated on your particular YouTube channel yet because it rolls out channel by channel. I prefer it at the top as well. So it is moving to all devices and all channels to be pinned at the bottom. So for those of you that still have it at the top, enjoy it. Enjoy it. EDB, hate the new Jewel pop-up thing too. I turn that off on my channel. So you shouldn't have that on my channel because I turn it off. But they won't let me choose where the pinned stuff goes. I thought it was broken. I was told it was not broken. My response, do we want to take 3 seconds to talk about this? I thought it was broken. So I reached out and was like, hey, because this was during the period of time that chat was acting all funny. And y'all would type something into the chat and then you would go to send it and it would just like get sucked into a black hole somewhere and it would never go anywhere. And chats weren't populating and chat would freeze. There were a lot of like platform chat weirdness going on. And so in that, I had reached out and been like, hey, chat's being, not y'all chat, but the chat function on YouTube is being glitchy and it's frustrating. And we've got like 10,000 people at once being like, WTF is up with this? Right. I'm like, we have enough of a sample size that if something isn't working on the platform, we're all going to know it almost immediately. So I was like, this is weird. Can we stop that? Can we stop with the glitchiness and the either way? And then my like polls and chats and stuff were getting stuck at the bottom on my end. And I was seeing it when I was on other people's channels as well. I'm like, it's on the bottom. I don't like, what is going on? So I reached out. I'm like, hey, I don't know if this is related to all the other things that aren't working, but this is weird. And then when I put polls up, I can't always see them and I don't understand what's happening. And what are we doing? And then it was like, that is weird. Let me reach out. And then the response I got was, so, that's working as intended. And I'm like, what do you mean that's working as intended? They're like, they've decided to move them to the bottom. And I was like, Yeah, B2, I agree with you. I find it very irritating at the bottom as well. It blocks too much space. So I was like, I do not love this at all. And they're like, yeah, they decided to move it. And I'm like, why are we doing that? So every time, for those of you that follow the EDB has a chat with YouTube sagas, it seems that the live team loves to see, I am being facetious in this, loves to see that EDB is like, huh, what have we done? And so there is stuff that they have shifted, and I have been like, what are we doing? Can we not? And I have asked repeatedly, hey, can you let me have the ability to toggle that on or off on my channel? Love that you want to have a new thing, love a new thing, but can you let me toggle this on or off? Almost, it seemed that nobody outside the product team that was dealing with chat knew that this was a change that was going to be made. Same with when they decided to change the way that your handles and usernames displayed on screen. Just no idea what was happening. So we first battled over the AI chat summaries. And when I tell you that I was the most annoying person, every single person I interacted with at YouTube, whether it was their department or not, I was like, hey, do you have 30 seconds for me to talk to you about AI chat summaries? Great. All the way up to the lovely corporate C-suite top tippy top executive in charge of products. And I was like, hey, do you have a second? I would love to talk to you about AI chat summaries. And we had a lovely chat. And I was like, this is my concern. This is what I'm seeing. This is what I'm seeing happening on the internet. This is how I see the internet doing things. And I understand while you're doing it, I understand the platform's goal. Can you give me an on-off button? I'm not asking you to kill it. Some people are going to love this, but can I have an on-off button? Because this might work great for like a gaming stream or like a just chatting stream. This does not work great for murder cases. Like imagine, and I'm like, imagine this scenario. And she's like, I see what you're talking about. I'm like, yep. And guess what? We got an on-off button. That's it. I don't want you to kill the summaries. Fine. Can we get an on-off button? Because in some chats, you might jump in and be like, I don't know what the fuck Burnt Peanut's doing, but there's an AI chat summary that lets me know what part of the game that they're at or what the chat is saying. Fine. Just toggle. I just need to toggle. And then, well, there was other stuff in between, but then there was the leaderboard thing. And when the leaderboard thing rolled out, I was like, what is this on my channel? What is it? What is this? What is this? It's like somebody coming into my office and moving my shit. I'm like, why is all my shit moved? Why were you touching my pens? What is this? And they're like, oh, it's great. I'm like, nope. Again, this might work really well in certain types of streams. But can you imagine that there is a chat gamification feature while we have witnesses on the stand? Do we see where this is a problem for me? This might work great in a gaming stream. I love that for them. This might work great in like a fundraising stream where you're trying to gamify fundraising or something. Fine. But if I'm covering a trial, can we not gamify chat also? I do not like the feeling of it nudging chat to be like, chat more and you'll get more points. No, leave me alone. So can we turn it on and off? And a couple people were like, I don't think they're going to turn it on and off. I'm like, okay, I appreciate that. And then we started having conversations back up the chain, and we got an on-off button. Wonderful. Hey guys, live streaming is a lot of things on the platform. And as a streamer who sometimes covers really sensitive things, I would love the ability to not gamify my chat. I don't like it. It feels gross. I hate it. Can you let me just not? also help me out so that inevitably when we're covering a trial, some media outlet, like they did during Depp, Heard, and others, is going to be like, oh, the YouTubers are modifying and gamifying and blah, blah, blah. Hate it. Hate it. I'm like, imagine the position it puts us in. And that's what did it. Imagine the position it puts us in if we can't turn it off. It puts us in a horrible spot where we have no control and it doesn't feel right. It's just not right. So can we just let us turn it off? Give me the option. And then we got a toggle button. I was like, right. Thank you. Because a lot of the products team thinks, this is my speculation, thinks about competing with other live streaming platforms for the use case that they're used to thinking through. They're used to thinking through the lens of like a gaming use case. I understand that. Live streaming is no longer gaming. Live streaming is the news. Live streaming is trials. Live streaming is where you can go to find out what's going on, or you can go watch gaming, or you can go watch cooking, or you can go watch whatever. But because streaming is so much more than just gaming, you have to give people choice so that they can stream the way that they want to. So then, when they moved the pinned comment, I was like, okay, look, my arguments about the other things are a bit stronger. This I just hate. So we're going to have that conversation a little bit more next week and see if we can just let us toggle it back to the top, please. We'll see. I might lose on that one. I've won the other ones. I don't understand the thought process behind moving it to the bottom, because for me, I feel like it blocks things coming up and I don't see it. I normally look towards the top of chat for pinned things and I just don't love it. So we'll see what happens, but we get to have that conversation. And I'm really glad that I get invited to be a part of those conversations to represent some of the streaming that's not just gaming. And I don't hate gaming streaming. I don't. Gaming streaming is great. Go game stream. I don't want YouTube to start building more towards just being a gaming streaming platform, because there already is a gaming streaming platform. I want to see YouTube, and this is just my thoughts. I want to see YouTube continue to build a streaming platform for all of the information that you need now. It is an information delivery platform. Sometimes that might also be gaming. But they're also live streaming Coachella. They're also live streaming sports. They're also live streaming life-saving weather information. They're also live streaming news, like with JB Buno. There's also a lot of things on the platform that aren't just gamified, and there needs to be balance between those two things for those of us that choose to stream informatively. And there is still a gaming streaming platform, and I don't want YouTube to be like, oh, we need to have all the features that platform has. We don't need to. It's fine. Just let us at people from mobile. We might actually get GTA 6 before we get adding from mobile. Emily, how many years have you been asking for that? All the years. All of them. All the years. I have been asking for adding on mobile for at least 4+ years. I'm working on it, guys. I'm working on it. I don't know how complex it is, but I am told that shifting the way that handles appear is part of the structure that needs to happen so that can happen. That's what I've been told. So we're going to keep having those conversations, and I will keep sharing those conversations. Sarah, so being able to like at a username on mobile and have it populate so you can just tap it so you can have a little bit more of a conversation in chat with other chatters much more easily. So tagging people on mobile where you can just do that. But I'm always really thankful that I get to be a part of those conversations, and I'm going to be doing some of that next week. We'll talk about that a little bit more because I will be on a little bit of a break to travel to have some of those conversations. And then, of course, we will talk about the things I'm not NDA'd on after that. But as I started to look at like what creators are going, I had to go to Travis and be like, can you please give me a rundown on who everybody is? I'm pretty confident that I am the oldest, if not one of two oldest creators that will be there. And I love that because our audience also has a perspective, and I want to make sure that the platform considers our audience in addition to considering our children, grandchildren, etc. Right? Us, we need to consider us too. So I'm always there to have that conversation, and I'll share some of the outfits I got. I'm very excited, but I'll keep you posted. So before we switch topics, this is a good time to remind you, one, get the Lawnerd app because there will be updates there during the week when I'm not streaming. Two, I will share some of the outfits there. And three, Lolly Lolly said, can you tell us? I cannot until after the event. That is part of the NDA. So not until afterwards. But afterwards I can. So I will be sharing that stuff in the app next week. We are going to move on to talk about Karen Reed stuff. I will continue keeping you in the loop with the stuff that we're asking for to just make the platform easy for us. It is my goal to make it an easy experience for you to be able to just put YouTube up on your computer, TV, whatever, and then be able to just use chat on your mobile device. That is my goal. That is my goal. So, my goal. Did you break the NDA by telling Travis? No, he's part of Team Baker. So he is part of my team. So I was asking him for help. He has been told that he cannot tell anybody, and he's like, I'm not going to. That's not a problem. So yeah, it would be nice to have some of those things. Miss Kim said, EDB, how come we can't watch members only from our TV? No one has been able to explain it to me. It is consistent on every members only video. You have to start the video and then go to like your watch history and grab it from there. I have no idea why. I have been trying to get an answer to that. It is a known issue. I do not know why. Nobody has explained to me why. It is a known issue. Again, we've been asking about that for maybe 3 years, but you have to go to your watch history to be able to grab a members only video on the TV. I have no idea, but it is a problem. All right. Are we ready? Are we ready to move on? All right. Let's go talk about Karen Reed. Yeah? All right. Shall we? Let's see. We are moving on to the civil wrongful death case. Emily, we just had a side quest chit chat, which is always nice when we have a day that we can have a side quest chit chat, but it will be an exciting week next week. So I will keep you up to date in the app next week. And then if we have some quick updates, they will be there, but I will not be streaming next week. So CC in the chat asked, I'm going to try to pull this up real quick because chat was moving. CC in the chat asked, when do we get all chat instead of top? I have asked and asked and asked. It seems that because now they've changed it to live chat versus top chat, it seems that there is a platform preference for top chat. And that the platform preference, I don't think is going to change. I have asked repeatedly to have live chat as the default. I do not think that is going to change. I have asked. So I have asked, but I don't think we're going to get that change. So I'll keep asking. But the thing I appreciate about YouTube truly is that when I have conversations with YouTube, they are incredibly open in sharing how they're seeing a thing on their end, because they're looking at platform as a global, or the platform is like the global platform. And so when they are making decisions, they are talking about how it works across the entirety of the platform And there's times I can understand pretty well how they're making that decision. And even though that would not necessarily be my preference, why they are making that decision. So they very much prefer, it seems, top chat being default, because especially top chats, especially chats that aren't moderated like ours, it filters out spam and repeated emojis and things like that. We do that on our own. So our chat, we don't need the top chat filter, I don't think, because our moderators do that, our team does that, and our community does that. Our chat is very different than other chats on the internet. I'm sure you've noticed. And so I think the process behind that is if somebody bounces into a chat on another stream, the top chat preference makes it so they're seeing the conversation happening and not the spam and stuff like that. We don't have that issue because our chat is amazing. So it is just a little bit of a cleaned up chat on top chat, which is not a problem here. So, and I didn't even know that was the thought behind top chat versus live chat, because we don't have that issue here because the law nerds are amazing. And why wouldn't you want to see everything in the chat? And if we have spam emojis or whatever, we have a process. Well, we have Nightbot that just pulls those out, so we don't really need it. But it is a very different experience on other chats in the internet. So some of that is what's going on. So with that, we are going to shift from the Inside Baseball. Oh, I promised I would share the untimely story again. Quick story time, then we're going to Massachusetts. We'll fly to Massachusetts. We did kind of a stopover in Utah today. Fair? Good. Chat's all on board? Fantastic. This is also why, we just let chat choose their own adventure. There was a period of time that I was working in one of my favorite courthouses. So I loved all of my colleagues. Some courthouses I liked more than others. The Long Beach courthouse was its own wild little ecosystem of my career. And I absolutely, there were good days, bad days, hard days, wild days. A substantial amount of all of the things that happened in my work life happened at that courthouse. I have fondness for it. I still probably have some residual trauma from it as well. It was a very busy assignment, but there was a particularly difficult attorney. That was me. That was my throat being weird. There's a particularly difficult attorney that our office was dealing with at that courthouse. And it is the anomaly that you have an attorney, and attorneys can be difficult advocates in court or stringent, ardent advocates in court, and then be pleasant and collegial when you're not in court. It's you've got to look at it kind of like professional sports where the you never know who you're going to have to work with down the road. So, don't start none, won't be none. You just try to be pleasant with everyone. And if people start with you, you're like, oh, well, I guess that's not going to work. But you don't take things that happen in court personally. You look at most of the attorneys and are like, you're doing your job. We're doing your job. Everybody just generally tries to get along. And this is not unique to criminal defense attorneys. There are prosecutors that are incredibly difficult and unpleasant to work with. This is just attorneys in general. It is not one side or the other. I had the benefit of being able to not have to do work with the prosecutors that could be difficult because I'm on the same side of the table, so our work didn't interact as much. But there were some challenging attorneys. Generally, they were not the rule. Most were able to get along perfectly professionally, if not in a very friendly way, throughout. This one was not the same. And I had a very sprawling case that I was dealing with that brought me into the courtroom where another DA was doing their work and this defense attorney had come in and I was waiting on my case. I had a case that had like 12. It was a 15 defendant case. I think 12 of them at that time were in juvenile and 3 were in adult court. It was a sprawling case. And so we actually had to move out of my courthouse that I was in at the time to a courthouse that could accommodate that many defendants and that many defense attorneys. You want to talk about trying to schedule shit. So I was in court that was not the court I was assigned to. This defense attorney was there. This defense attorney and I had worked together. We had trials together. We had a trial where the judge wanted to sanction her after trial together. All kinds of stuff. This was an ongoing and difficult issue. So I'm in court with the DA I very much liked and respected. And the DA is sitting up at counsel table. And the counsel tables are just like a long table. The bench is up there. The jury box is to the side. Then the audience is to the back. And the bar separates the audience and counsel table and what have you. And so generally in the courtrooms I was working in, there was counsel table and then there was like a row of seats behind counsel table along the bar where you would just sit and wait for your cases if you weren't sitting in the jury box waiting for your cases. So you weren't sitting in the audience. You were sitting in front of the bar, but not at counsel table. So that's where I'm sitting. And the defense attorney walks in and the DA is just sitting at the table doing their work, waiting for the court to come out. And the DA is just sitting there with all their files like stacked next to them to do their whole day of calendar. And the defense attorney comes in with a piece of paper and like walks to the side of the table as the DA is sitting there working at the desk and like slides it onto the table and walks away. Like just like walks up to the table and is like, boop, and then walks away. And from where I'm sitting, kind of to the side and behind the DA, I see the DA kind of look up from what they were writing on a file. Hey, T. We were mid-story. How are you, buddy? Heading to the dentist? Okay. Give me 30 seconds. Chat, give me 30 seconds. T's got 2 questions about his doctor's appointment. So I'm gonna throw on a little bit of music. I will be 2 seconds. Oh, no. We'll throw on the hold music. Give me 30 seconds. Oh, we've got to say hi to George. Well, we've got to say hi to George before we have a conversation. There he is. There's the George. All right. Give me just a second, chat. We will be right back after this quick parenting break. Hi, Georgie. Hi, buddy. All right. I'll be right back. Thank you, Chad. I appreciate that. All right. We were mid-story and everything. All right. T had some questions because he needs to bring new things to the doctor because 18. So we had to answer the 18 things. Thank you so much. I appreciate it. So we're in court and I see this whole thing unfold and the defense attorney's kind of sliding the papers up onto counsel table and the DA is like writing in their files. Didn't say anything to the DA. The DA is writing in their files. And I see the DA kind of look up. And when you're assigned to a courtroom like this, it is generally an assigned DA, an assigned defense attorney. So you are working together on day in, day out, so many cases. You are constantly working together. Which, if that relationship is difficult, is difficult. So, slide some paper onto the table. And the DA, I see the DA just kind of look up, look at the paper, flip it over, because it was face down, flip it over, look at it, and just go, as loud as I have ever seen anyone be in court. Untimely. Take the motion and throw it behind her. Just picked up the papers, yelled untimely, and hurled the motion papers behind her. Just, whoosh. I have never seen anyone throw a motion like that. Ever. Just ever. Just whoosh. Untimely. And I was sitting in court and I was like, oh, they're going to fight. But the defense attorney had to have known that this was going to be the problem when tiptoeing and putting the motion on the table. This was also during a period of time where we were having some, in our kind of section of the county, we were having some fuckery going on, and it was causing a significant amount of tension, and there was some gamesmanship going on. And that happens on occasion, but there was just some fuckery going on. So it was it was a difficult time in juvenile court. So this was part of that time during that same period of time. And this is a conversation for another day, but during the same period of time, one of the defense attorneys at my courthouse was brought to court in handcuffs for violating the court orders. It was a period of time. On the side with TIC said, I remember that. I was a court reporter. Do you remember the untimely motion getting hurled, or the period of time where the Los Angeles County juvenile courts were having issues with juveniles being transported all over the county because all of a sudden people were non-stipping? It was a mess. Either way, we had a lot going on. And so the motions that were not being filed on time were just, look, if everything is genuine, we can find a way to work it together. But when things are trying to gamify, everything's over. So the untimely was one of those moments that will just stick in my head, because I was like, damn. This was before the judge was on the bench. The judge was not on the bench yet. This was before. Juvenile court's its own little thing. And the things that happen in juvenile court are not always things that you would see happening elsewhere. Yep. So I've seen judges storm off the bench in juvenile court. I stormed out of court once in juvenile court. I've seen juvenile court's its own strange little segment of practicing law. But I digress. Stories for another day, or probably a members only. But there are times in juvenile court where you are just done. So the untimely was one of the greatest things I ever saw, because I felt that in my soul. The way that we sometimes yell at what's going on in court, and you're like, I felt that too. That was one of those moments where I'm like, I felt that too. Like, I felt that too. For sure. So, are we ready to go to Massachusetts? We do some story time streams, mostly in our members only. They are not always on members only, because when stuff comes up, and we have time to bring everybody up to speed, I don't want anyone to miss out on the some of the inside jokes. But when I say untimely, no, that I am also thinking of hurling papers in the courtroom because it is just untimely. Yes. Felt that in my soul. I was like, yep, it is untimely. They yeeted the motion onto the floor. It was, in fact, untimely. So we're going to go to Boston. We're going to talk about the civil wrongful death case. And then we are going to, answer questions. And then we're going to wrap up for the week because I've got a ton to do before I travel. And I have some new stuff I'm working on for the podcast. It's going to take me just a little bit of time. So I need a little bit of time. But for those of you that are members here and members on the app, we will be doing a podcast recording. What time will that be? I'm not sure. And a number of you have said, ADB, we got a notification for a members only video. Yeah, it was somehow still not listed right, so it wasn't showing up. There were a couple more that I found, so you're probably going to get a number of those today as I change the status of some of those things, because some of them are just, I don't know what happened, but some of the older members only streams were not showing up right. So I was toggling them back to members only. So it might push a notification. They're going to be older things. I'm going to do that later after stream. So it's just all done at once. So it's not like, wait, what? I didn't realize it would push out a notification, but you'll see it. It was an untimely notification. Exactly. Untimely. But I also, when I was going through things, I was like, oh, that's weird. So there's a few things I'm going to go, shift them back so that they show up again in members only. So you'll probably see them as I do that. So don't worry about it. All right. It's not just y'all. Let's go to Massachusetts, shall we? Shall we? I think it's time. We'll fly. Let's do that. Did I finish the coffee? No, almost done. It's just a chit chat stream today. Because, we've got time, which I love. All right, you guys, it's time to go to Logan. Let's go. Let's go to Logan. All right. Catching up from where we were on Tuesday. We were talking about Karen Read sues them all. Karen Read versus everybody. Karen Read versus the House defendants and Proctor et al. We talked about Proctor's phone, the audacity, all of the things, because Proctor's also having a discovery fight. There is a discovery fight ongoing in the civil wrongful death case. So just for a bit of a where are we? After Karen Read's acquittal, she had to resume the wrongful death case brought by the O'Keeffes. The O'Keefe family, in a variety of different ways, and as representatives for the estate, what have you, brought a wrongful death case against Karen Read and against the bars. I think that there are parts of that case that are going to be quite difficult because the part of the lawsuit against the bars involves Karen Read being overserved. However, we saw through 2 trials that the people who knew Karen Read, including those that were not drinking at the bar, did not perceive her to be incredibly intoxicated. So if the people that know Karen Read do not perceive her to be incredibly intoxicated, I don't know if you can find that she was overserved by any of the bartenders, because if people aren't perceiving her to be drunk and they know her, how are the bartenders supposed to perceive that she's been overserved? Also, to the best of my memory, when they got from CF McCarthy's to the Waterfall, I don't think that she purchased any additional drinks at the Waterfall. If she had a drink, it was either the one that she brought with her or one that John purchased and gave to her. But I think once she got to the Waterfall, it was the drink that came over with them. And then John had bought drinks. I don't think she purchased drinks at the Waterfall, to the best of my memory. I might be fuzzy on that, but the bartender wouldn't have even had an opportunity to perceive if she had been overserved and then not serve her. So I think there are some difficulties with the wrongful death as to the bars and whether or not Karen Read was overserved. The difficulties against Karen Read will be different. I think the bars are probably going to try to settle. But you never know. So in the context of that civil wrongful death case, the defenses being fought by Karen Reed are slightly different than the defenses being brought by the bar, because the bar defenses are she wasn't overserved. That's their defenses. But the defenses from Karen Reed are, I am not responsible for John O'Keefe's death, and here's why. So some of the arguments that that Karen Reed is going to be bringing are similar to the arguments that Karen Reed is going to be bringing in the civil federal case. The civil federal case is Karen Reed suing Proctor, Tully, Buchanan, the McCabe's, the Alberts, and Higgins. So they're all getting sued in the federal case, but it's going to be a lot of analogous arguments, because the argument in the federal case is that the law enforcement officers being sued personally are being sued for malicious prosecution, deprivation of rights, and the House defendants are being sued for essentially aiding and abetting in that, to boil it down to a very broad overview. So we're going to see similar arguments in the two cases, but we're also seeing these fights for discovery that are kind of nuanced, because when you're looking at like the Proctor phone situation, the Proctor personal phone problems is stemming from criminal cases in state court for defendants, not Karen Reed, where Proctor was the investigating officer. And so there is discovery fights happening in or under the umbrella of these 5 cases or 5 defendants where Proctor was the investigating officer, and the district attorney's office was turning over information from his phone that might go to bias, that is information that has to be shared. So that's in the Miles King kind of et al. Cases. Then, when you get to the civil wrongful death case, there is also an ongoing fight over discovery. The Proctor personal phone stuff was turned over to Karen Reed's team with regard to being able to use it in the civil wrongful death case where the O'Keefes have sued Karen Reed, versus the civil federal case where Karen Reed is suing. Karen Reed's team, and we covered this Tuesday, is asking for an embiggened order to allow them to use that to also sue the town of Canton and Massachusetts State Police. There are different hurdles you have to jump through to sue government entities versus suing individuals, and that suit has not been brought yet. But we learned from those filings that that is being contemplated. I bring that up now because we are going to be talking more about a discovery fight with Canton. And I'm probably going to keep referencing back to Proctor fighting over discovery with Karen Reed in the federal civil matter that we looked at when he's like, I need to refresh my recollection. I bet you do, but you're going to have to go subpoena it from everybody. And I wonder if when Proctor tries to subpoena all these things, he's going to run into the same fights that Karen Reed is running into against the town of Canton. Now, there is a hearing set for the motion to compel that we're going to look over today on May 7th. That is the day before Brandon Banfield's sentencing. I do not know if I will be streaming it that day because we are streaming Banfield the next day. It might be a hearing that I stream because the judge isn't going to make a decision that day. It might be a hearing that I stream the following week and we go back and take a look at it. I'll keep you posted. We also need to update what happened with the emails or email. Emily, what email? That reply all email. So you'll remember that there was a fight going on because Karen Reed's attorney, we watched this hearing, the attorney with the South African accent, that attorney was arguing that the O'Keefe's attorney should delete and destroy, not seek and destroy, delete and destroy the email that Karen Reed had accidentally hit reply all. That attorney was like, this was my bad. I forwarded that information to Karen. She hit reply all, didn't realize that plaintiff's counsel was on that email thread. This was a error. And we told them like within 45 minutes, by the way, that wasn't meant for you. Can you please delete it? And the attorney for the O'Keefe's was like, nah, you sent it to me. I'm keeping it. And They had a hearing on it. This is normally one of those items of professional courtesy. It's clearly not meant for you. You would want the same courtesy if the shoe was on the other foot. So, extend the courtesy. Instead, it had to go to hearing, and they were all fighting it out as like Brady Bunch boxes on a Zoom call. The court has made a ruling on that. And so we're going to look at that first before we jump in to all the rest of it. I think that's the most helpful. And of course, the docket I pulled up before stream has now timed out. I'm still not a robot. Can I please have the docket back? I was all ready to go. I mean, as much as we are like prepared in advance, I was ready to go. And then. All right, let's just pull this docket up one more time so you can see it, because it's a docketed item. It's not a written order. And there are a few other rulings that we're going to take a look at in addition. Oh, wait, that one's an endorsement. Hold on. I can grab that one. There's a scheduling order that's not printed out. The amount of documents we now have to deal with the amount of litigation here is significant at this point. So Massachusetts does a few things that are quirky. And one of those things is that there are times that the court just endorses the motion instead of issuing a written order. That's what we're going to take a look at now. It's like a photocopy of a photocopy of a photocopy. Yes. I downloaded this off the docket. It is still a photocopy of a photocopy of a photocopy. I know. It is a unique quirk. Federal courts sometimes do this too, but I've never seen a photocopy look like this. In federal court, y'all, I don't even know. So this is the court's endorsement, which means the court has typed their ruling onto this motion. This is Karen Reed's motion for order requiring plaintiff's counsel to destroy inadvertently produced communication. This text box up here with the signature, that's the court's order. So here's the court's order on the reply all email issue. March 27th, 2026. As noted in the Charm case, a client who seeks to preserve the attorney-client privilege has a responsibility to be careful, particularly when using a means of communication that poses known and obvious risks. Although this defendant did not meet that responsibility, the importance of the attorney-client privilege in our legal system outweighs that failure. Defendant's motion seeking deletion of the email and any copies is allowed. Why you shouldn't have reply all'd. The court's just like, Oh, Lord. All right. Though the defendant did not meet that responsibility, it only happened once. Defendant's motion seeking deletion of the email and any copies is allowed, although plaintiff's concern about potential use of the email for impeachment purposes may appear to the defendant as unfounded. If such concern becomes reality, the issue is preserved as the email remains under seal with the court. There you go. Plaintiff's attorneys don't get to keep a copy. They are ordered to destroy every copy. That's going to have to go on, I trust that you do it when you say you do it, or you can end up completely sanctioned. And a copy of the email is under seal with the court. And you can't unring the bell. You can't put the shit back in the horse. That the attorney for the plaintiff has already read this. So the court says the concern is if Karen Reed says something in the course of deposition or the course of all the rest of it that is contrary to maybe what's in this email, then the issue can come back up before the court and say, no, but I get to use this as impeachment. And so that's where the court says that issue is preserved. So I still don't know how all of this happened, because a number of you are saying, how do you even reply all if you're BCC'd? I know, Sarah, I don't know. I don't know. I also would like to see the email string. I don't know. I don't know. Look, here's the thing. It is on the lawyers to be incredibly careful so that their clients are not in a position to oopsie-doodle an email. And we talked about this on the podcast a few weeks ago when we were talking about Sheriff Nanos, and Sheriff Nanos had responded, and it looked like he meant to respond internally, but had responded to a reporter asking questions, and the response was ignore her. And it seems like he had meant to send it to like his team, but had actually sent it to the reporter. We've talked about this a few times recently. So I don't know what happened, and I don't know how it happened. We're not going to see it. Let's see. There is also a note here that, again, why are we doing this to me? Hold on. I bet there's a way. I bet I can flip this. Put that thing down, flip it and reverse it. Is it worth? I bet I can. Hold on. Let's see if I can. There's got to be a tool in here somewhere. Maybe not. Tools. Can we flip it? No, maybe not. I don't know how to do that. It hurts my head to try to read this. A lot of you are saying, oh no, you absolutely can reply all in a BCC. Again, not my area of expertise. I would love to see what happened here. February 6, 2026, virtual hearing held Tuesday, February 17th, 2026, at whatever time hole punch precludes. Counsel for plaintiffs and defendants shall notify who will be arguing. Counsel for other parties are not required to appear if they do not wish to do so. Plaintiffs' attorneys shall not disseminate the email at issue or allow any further review pending. So that was just the court. So the court noted on the side of the document that they're having a hearing, and then the court noted they're ruling on the document. Why do they do? I don't know why they do this. I don't know. 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 It's confusing to me too. The court's just making notes all over the document. There's just notes everywhere. What are we doing? So I tried to rotate it. I couldn't figure it out quickly and I wanted to move on. So I'm sorry, y'all. I tried to rotate it and I didn't want to fight with it for 15 minutes because we have so much more to cover. And I was waiting for the docket to come up. All right. And now that the docket is populated, we can go to the next dates on this. Let's see. The court is, I'm just going to put the docket up on the screen. There it is. We're going to have to do this slightly differently. Even then. All right, we'll just do it this way. The docket is up on the screen showing what the dates are. There is an endorsement on a motion to continue that's been allowed. That's from today. I'm going to pull that up. We'll do that first because we have new file. Oh, wait. Those are from the 16th. Today is the 16th. It's actually the 16th. Hold on. New information. We have new information. We have a bumper for that. We actually have new filings. Look, we're doing it as it happens. Emily, we don't do breaking news. Court dockets are a little bit easier because it's discrete. It's not going to keep evolving and we don't have to worry about, well, fuckery, yes, but we don't have to worry about like, is this what it says or not? It's just on the court docket. It's just on the court docket. We have new filings. I like our bumper. New filings. Let's go. All right. The court is granting a motion to continue. The motion hearing to compel is scheduled on 4/28/2026 at 3 p.m., rescheduled for the following reason. Other interested parties, Town of Canton. So when are you hearing it then? Because down here on the 9th, it said that there was going to be a hearing. Cases continued to April 28th at 3 p.m. for hearing on the motion to compel, and May 7th for Zoom for further status. Okay, so the motion to compel that we're covering today was supposed to be heard on April 8th. That is being, or April 28th. That's being continued today from April 28th. Okay, well, when are we doing it then? All right, well, if I said earlier that this motion was going to be heard on April 28th, incorrect. If I didn't say that yet, look at us. It's like we know things. All right, this hit the docket today as being allowed by the court. Do you notice that the way the court did the court ruling here? The ruling is literally the judge just handwriting allowed with the date stamp on it. Motion to continue. This was filed on April 15th, granted by the court April 16th. That handwriting is the motion being granted. All right, so before we're going to look at the spoilers here real quick before we get to the rest of it. All right, now comes the Town of Canton with the assent of defendant Karen Reed through her counsel. Well, that, I mean, at least everybody agrees. Defendant Reed's motion to compel the town of Canton to produce documents pursuant to non-party subpoena currently scheduled for Tuesday, April 28th at 3 p.m. be rescheduled to the following Tuesday, May 5th at 3 p.m. or sometime thereafter convenient to the court. As reasons thereof, counsel of the town of Canton will be out of the country due to pre-planned travel during late April and early May and is unavailable. How are y'all traveling? So everybody's just out of the country. What? All right. Well, have a great vacation. Have a great vacay. Let's all go. Have a great vacay. Excuse me, Your Honor. I'm going to be out of the country. But when was this hearing set, though? Like, how are we just discovering this? Hold on. When was this hearing set? This hearing was set on April 9th? Yeah, they set that hearing on April 9th. April 9th. Case continued to April 28th. How did it take that long to respond? Shouldn't you have responded on like the 10th? Or the 11th? Like, how did this take this long to be like, I'm not available that date? To be fair, the Town of Canton representative probably was not on the call, but it's like a week to respond that you're unavailable for the hearing. All right, well, the hearing on the motion to compel is getting continued. With regard to the Town of Canton. All right. So, May 5th, we are now entering the dreaded time of year when everyone is going to be incredibly busy and all of the things are going to start getting bumped around because of graduations, vacations, summer. We're in that zone where everything gets a little squishy, especially when it's civil cases where there's no statute in the same way to compel them to move quickly as in criminal cases. However, in Massachusetts, the criminal cases aren't moving that swiftly either. So that's getting continued. Well, I guess as we look at the fight over discovery with the Town of Canton, we now know that that hearing will be held on May 5th as it was continued. Well, the continuance was granted on April 16th. Let's take a look at those motions now, because that is really what we wanted to talk about, is the fight over discovery with the Town of Canton, Remember, Karen Reed still intends to sue Canton. So we're going to take a look at where is our notice of motion. There it is. So we've got notice of motion and motions. They are in two separate documents. So you're going to see that real quick. But Emily, why are we covering the notice of motion? Just for thoroughness, to make sure we don't miss anything, because it's so much easier when we just pull it up and we all look at it together. Like, let's just see. That's how we want to do that. All right. Defendant Karen Reed's motion to compel the town of Canton to produce documents pursuant to a non-party subpoena. Canton's not a party to this lawsuit. Defendant Karen Reed requests the court to compel the town of Canton to produce all documents that are responsive to the subpoena that Karen Reed served on it over a month ago. Remember, when this judge took over, one of the hearings that we covered, the judge asked the attorneys, hey, why is stuff dragging along so much? If you have issues with discovery, come to the court and ask for help. And one of the attorneys said, do you want us to change our obligation? And the court said, no. But if you've followed all your obligations to ask for discovery and then you're not getting discovery, you need to bring it to the court. You can't just literally let it linger. You have to bring it to the court and then ask the court for help to compel the discovery to get done. You don't wait for months and months and months and months and then come to the court and be like, well, we don't have discovery. You should have brought this to me 3 months ago. You don't just put it on a back burner. Let's go. So the court is doing that, saying, or the Karen Reed parties are doing that, saying, the subpoena seeks documents relating to Canton Police Department's investigation into Sergeant Sean Goode. We talked about this when it initially came up. How many months ago was that we talked about this? Hold on, it was months ago that we talked about Sergeant Sean Goode. I think I remember it acutely because I said, or titled that video, Not Good. And I was like, oh, the opportunity presents itself and we are taking the opportunity immediately. November 4th, 2025 is when I covered that Sergeant Goode was suspended. November 4th, 2025 is when he was suspended. Oh, Emily, keep reading. It's literally on this sentence. All right, well, it says late 2025. I guess we could have guessed. The subpoena seeks documents relating to Canton PD's investigation into Sergeant Sean Goode's alleged misconduct, which led to him being placed on administrative leave in late 2025. Reed's counsel has been conferring with the town's council in good faith for months about these documents. Initially, the town's council expressly represented that the town did not possess documents that are responsive to the subpoena, but now, months later, the town acknowledges that it does in fact have documents, but objects to producing them. However, the town has not asserted any objection that justifies withholding the requested materials, and its conduct further delays the party's ability to move this litigation forward. The documents that Karen Reed seeks are well within the scope of Rule 26. I wonder why they need to go through the town of Canton and not the police department. It just might be that that's who the record keeper is for the police department. That would be my guess. So Reed respectfully requests the court allow this motion and order the town to produce all documents responsive to Reed's February 10th, 2026 subpoena within 10 days of the order. Your Honor, we have been asking them since February. Where are the fucking documents? Maybe this is why Proctor is nervous to try to get discovery. Because Proctor is asking for discovery from MSP. Isn't he also asking for discovery from Canton? Yeah, I thought so. That's so difficult, isn't it? All right. Let's take a look. That is the notice of motion that kind of lays the groundwork for what we're going to be looking at together. Let's take a look at the memorandum of law connected to this motion as we pull this up on the other monitor. Defendant Karen reads memorandum of law in support of motion to compel the town of Canton to produce shit that they should produce. I summarized the title just a little bit. Took a little liberty with the title there. Karen reads motion for why the fuck won't you just give us the discovery at this point? Seriously, are we still here? Are we still here? Defendant Karen Reed respectfully requests that the court compel the town of Canton to produce all documents responsive to the subpoena. Reed served it over a month ago. That subpoena seeks documents relating to the Canton Police Department's investigation of Sergeant Sean Goode's alleged misconduct, which led him to be placed on administrative leave in late 2025. A lot of you are asking if that is paid leave or not paid leave. I imagine the administrative leave is probably a paid administrative leave because they cannot suspend him without pay without an investigation being completed. That would be my supposition, but Canton might have other quirks, but my supposition is it would be paid until they go through process to turn it to unpaid, right? So paid leave in 2025. Reed's counsel has been conferring with the town's council in good faith for months. This is what we saw in the notice. So we're going to skip over that to the argument. Reed has now served 2 subpoenas on the town of Canton seeking documents from Canton PD. Reed served her first subpoena on the town in July 2025, and the town produced certain Canton PD documents in response. Oh, look at that! They got some of the documents. That response is not being challenged here. However, in the fall of 2025, Reed learned that Goode had been placed or had been suspended from Canton PD after Reed's acquittal and that the town was investigating him for alleged misconduct. The town's investigation into Goode's conduct is relevant here because he was working the night John O'Keefe died, answered the 911 call reporting Mr. O'Keefe's death, and was one of the first police officers on scene at 34 Fairview. Testified at Reed's criminal trial, and was a close friend of Michael Proctor. More Proctor problems. The lead detective who investigated Reed, as well as individuals that were in the house the night, or in the house on the property where O'Keefe's body was discovered, that's the weirdest freaking sentence. Thank you, Trev. It's just an awkward sentence that as well as individuals that were in the house on the property where O'Keefe's body was discovered and their family members. Yeah, it's just an awkward sentence. It's an awkward sentence. What's up, buddy? Okay. You brought all the cats to stream. Do you want to, Fred looks like he is just, Fred's just fretting. Fred's fretting. George is mad that you're carrying Fred. Yep, there's George. Like, why are you? Yes. And Fred is just like, what are we doing? So yes, other Proctor pals, more Proctor phone problems. All right. Have a good one. Don't forget to limp roll your shirt. You're covered in cat hair. Mm-hmm. I will. Same. Drive safe. So we know now that some of this is due to the Proctor phone text messages. We saw that in the suspension. We saw that in other reporting, and we saw that in some of the phone motions that we went over on Tuesday, that it is supposed that part of this is due to the Proctor phone dump of information, that after all that phone information came to light, Canton PD is like, oh boy, we're going to need to take a look. They go on to say, fuck, I need to make the keep reading emoji.
According to media reports, Goode's post-criminal trial suspension was based on his interactions with Proctor. Keep reading, Emily. It's just same. Footnote 1. We got to get the footnote voice correct. Footnote 1. CEG, Canton police officers' alleged misconduct stems from Michael Proctor investigation, I-Team sources say. And then they link the article from November 3rd, 2025. Canton Police Sergeant Sean Goode suspended for, quote, misconduct allegations. Its department faces turmoil after Karen Reed trial, Boston Herald, November 3rd, 2025. And then they link those. Shortly after learning of Goode's suspension in December 2025, Reed's counsel contacted the town's council to determine whether the town would produce documents relating to its investigation pursuant to Reed's first subpoena. I imagine their response was along the lines of, where is it?
Nope.
Yeah. In a phone call with town's council, the town's council informed Karen Reed that the town did not have any documents relating to the investigation or Goode's alleged misconduct other than the letter placing him on leave. Yeah, we don't have any. No, we don't have any. We don't have any. No documents. Sorry. There's no documents. We just, we just have it. We just have it. Let's see. When Reed's counsel repeatedly attempted to confirm that representation in writing over the course of several weeks, the town's council refused to respond. Oh boy. Well, why won't you put it in writing? Why won't you put it in writing, boo-boo? That's always sus. Look, this is just standard practice, not just for lawyers, but for many, is that when you have a phone conversation or reach some kind of an agreement, you just confirm it to email. Hey, following up and confirming our conversation, this. So why won't they reduce it to writing? We're soundboarding it out today until we get familiar with where I moved everything, because all of the things have moved. By the next time we're in trial, we'll get it.
Don't be suspicious. Don't be suspicious. Don't be suspicious. Don't be suspicious.
Why aren't you writing it down? Right. So Karen Reed's lawyers are going to be like, that's weird. You don't want to seem to write that down. Strange. Goes on to say that later other attorneys representing the town informed Reed's counsel that the town may in fact have additional documents related to its investigation. So weird. But that the existing subpoena did not specifically cover those documents and that the town would object to producing them in response to that subpoena. Okay, well, we'll just issue a new subpoena. We'll just issue a new subpoena then. New subpoena. Let's see. Give me 1 second, because a lot of you are having some platform issues with chat being weird. I just want to let YouTube know so they can pop in and take a look. Thank you, chat. I realize that I need to also be careful when I say chat issues, because I don't want somebody on replay crew to be listening and being like, ooh, what's everybody saying? Are they getting spicy? No. Chat's lovely. There are some platform quirks that are causing frustration. So let me make sure that I ping those so that they know about the glitching and that y'all can hopefully refresh. And if that doesn't work, they can take a look. But it's helpful for me to tell them in real time so they can try to look and see if they can find the error reports. So thank you for letting me know. I very much appreciate it. But it's
the platform is not working as anticipated. Spicy. But not chat. Chat's lovely. Chat's not getting spicy. That happens on occasion, but not today. Because at this point, I think we're all just like, oh, wow. Oh, wow. So weird. Canton's like, oops a doodle, we don't have any. Oh no, we might have it. No, we might have it, but we're not going to produce it under the previous subpoena. Fair. Look, it is the obligation of the lawyers to build in the friction of saying, if we don't have to provide it under that subpoena, we're not going to provide it under that subpoena. But then when they get a new subpoena, then maybe cooperate. Reed's counsel served a new, more specific subpoena on February 10th, 2026. Right. The town of Canton doesn't have to embiggen their understanding of the subpoena to make it work. New subpoena is proper. Great. So, new, more specific subpoena, February 10th, 2026. A copy of that subpoena is attached as Exhibit A. Goody. In the context of Rule 9C conferences, Reed's counsel proposed that the parties discuss a compromise whereby the town would produce at least some of the relevant documents or produce documents subject to confidentiality restrictions to address the town's concerns about its ongoing investigation. Look, as annoying as my nosy ass finds that, that's fair. That's fair. It is annoying, but also there is an ongoing investigation, and also Goode might not know. Goode might not know what is going on with everything in the investigation at that point. Also, there might be others that are brought up in that investigation that might not know. That should be kept to the ongoing investigation, lest we give anyone else the opportunity to decide that now is the time for a new phone, right? Fair concern. That does not bother me. If there is confidentiality restrictions in place, I would love to know more, but it's fine. We'll learn at some point. Continuing on, that the town's council represented that he would consider this proposal, but never followed up, except to send a standard Rule 45 objection letter and continue to refuse to produce a single document. Oh boy. We're not going to do it under this subpoena. Sends new subpoena. We're not going to do it under that subpoena either. Girl, what? And now we're here. Right. Great. As it stands now, the town objects that Karen Reed's request for documents relating to the investigation of Goode's misconduct are overbroad, that those documents are irrelevant, and that it will not produce documents related to an ongoing internal investigation. The court should reject the town's objections. In this case, plaintiffs allege, among other things, that Reed created a false narrative that the police investigation into the O'Keefe's death was corrupt, biased, and designed to frame Reed. Goode's conduct is directly relevant to this issue because he played an important role in the initial response to Mr. O'Keefe's death and, as a result, Karen Reed's criminal prosecution. He answered the originating 911 call, was one of the first police officers on scene, testified at Reed's first trial. Goode was a close friend of lead investigator Michael Proctor. Also, can I just side note on this? Side note, I got a question here. If Goode is a close personal friend of Michael Proctor, wouldn't Goode also be aware of Proctor's relationship with the other people involved here? Like, you know who your friend's other friends are, especially when we're deep into small town shit. So doesn't Goode also know that Proctor is also friends with everybody in the house? So isn't Goode also aware that there's a potential conflict here? Or is that a bonus where Goode's like, oh, it's Proctor's case, y'all. It's Proctor's case. We got this. it's a fair question if one of the initial responding officers also knows that the MSP trooper who's now in charge of this investigation might have a conflict. Because one would hope that you would look at that and be like, hey, town of Canton has a conflict. You also probably have a conflict. We should send this elsewhere. Because Canton conflicted out of this shit quick. Wouldn't Goode also know that? I think that's completely relevant. I really do. What did Goode know about the investigating officer? Y'all are friends. And are you texting Proctor about this case after Canton is conflicted? Purely my speculation, but I think I would be much more surprised if Goode's not texting Proctor about this case than if he is. Because I think Goode's probably texting Proctor all up one side and down the other about this case on the personal phone, and that's part of what's going on here. But after Canton was conflicted, he shouldn't have been talking about this investigation at all. I would be surprised if he wasn't. I don't know that one way or the other, but I would be surprised if he wasn't. So I think it is incredibly relevant to the civil defense that all of this was corrupt from the beginning. And she's allowed to pursue discovery to do that. And in this lawsuit, they can't say that Karen Reed brought this lawsuit to go fishing for discovery to sue everybody. Because she's the defendant here. They needed to build a wall between the conflicted parties and the investigators in this case, and they didn't do it. And it still boggles my mind that they didn't do that out of respect for John O'Keefe. It still makes me buffer that they didn't want to do everything to dot the I's and cross the T's to make sure that they figured out what happened to John O'Keefe. And I got a lot of questions that I'm not going to start pontificating on until we're done with all of this. Because maybe some of them will get answered, maybe they won't. But one would hope, right? And that's absolutely not what happened here. Hippie Fluffy said he was just a guy. They had no respect. It seemed that way. Tell him the guy never came in the house. It seemed that they had no respect for him, which is shocking to me. It still shocks me. Shock maybe isn't the right word anymore. It still infuriates me. So continuing on, I think that the relevance here is apparent. They go on to say that Goode was also a close friend of lead investigator Michael Proctor. Goode's alleged misconduct is reportedly related to interactions with Proctor. In fact, oh, good tea. In fact, according to newly received documents from the Norfolk District Attorney's Office, Goode and Proctor are close, longtime buddies who fucking keep reading. Emily, the soliloquy. I know, I can't help myself. Goode and Proctor are close, longtime buddies who frequently exchange vile messages while both served as police officers. What's in those messages? Canton shouldn't have been talking to the lead investigator about this case, Karen Reed, or the rest of it. And I'd be very surprised if they weren't. In addition to the vile messages. And honestly, in a lot of cases, if the defense was talking about vile messages, I might be like, okay, well, are we talking about Bryce and Eric texting each other about an open marriage? Like, I will side-eye that in a lot of cases. Are we other uses for your throat? What kind of vile messages are we talking about? Not in this case. Not in this case. After we've seen what we've seen, not in this case. Other cases, a little bit of a, we need to see all the text. This case is not. Nope. Nope. You have lost the benefit of the doubt with me based on what we've already seen. The evidence has changed my mind that when they are saying vile messages, that they are not being hyperbolic. Other cases, I'm going to wait and see how that pans out. This case, we've already seen it. So I take that at face value. They go on to say, thus, documents related to the town's investigation into Goode are relevant to the claims and defenses in this action and are discoverable. See Massachusetts Rule of Civil Procedure 26B1, parties may obtain discovery regarding any matter not privileged, which is relevant to the subject matter involved in the pending action. Do you think that this is involved, chat? I think it is. Let me know what you think. They go on to say, moreover, the town's assertion that the requested materials relate to an ongoing investigation is not a valid basis for refusing to comply with the subpoena. The town's investigation is an internal personnel matter, not a criminal investigation, in which disclosure could risk jeopardizing a prosecution. Indeed, the town's objection letter does not explain how producing the requested documents could interfere with its ongoing investigation into Goode. Moreover, documents related to internal investigations of police officers are discoverable and must be produced in response to subpoenas. Right, a protective order fixes this, though. Like a protective order fixes this, though. That's all. If you're worried about it, just limit how it can be used to just this case. Fine. Sure. They go on to cite case law that says police internal affairs investigations, however, are not privileged by statute or common law. They go on to say documents relating to the internal investigation into Goode's conduct are therefore properly subject to Reed's subpoena. The court should order the town to produce them. Conclusion: make them produce them within 10 days. Let's see what this exhibit is. Exhibit A, not Exhibit E, not Exhibit Y. Exhibit E. Keeper of records. Also, I like keeper of records as the official title. We don't see that everywhere. But I like the keeper of records title. It feels so dignified. To the keeper of the records, please produce the records. It just feels so formal. I like it. I like it better than the custodian of the records. I do. Emily, that's a weird thing to have a preference on. I'm delighted by some of the language in other courts. Look, South Carolina gets a cloak of justice. I like keeper of the records. I like affiant further saith not. I love it. I'm here for it. This is the language of the subpoena. The documents identified in Schedule A. Send us the shit that we're asking for, notarized. Definitions, lawyers have to define things because you have to define things. Who knows? CPD means Canton PD. Town means town of Canton. Documents means documents. Written, printed, typed, or other graphic matter. Printouts, runoffs, or any printouts or runoffs now or at any other time in your possession. They've got to make sure that they cover all their bases because lawyers will find loopholes. And so you've got to try to close all the loopholes. Let's see. Instructions, documents withheld. If any document is withheld under a claim of privilege or other protection, so as to aid the court and the parties, you must identify all of the things. Tell us what privilege you're asserting. Let's see what they're asking for. Document requests. All documents, video, audio, recording, communications, including all things covering the disciplinary investigation of Sean Goode. I don't think that's overbroad. They've limited it to the investigation of Sean Goode. How is that overbroad? They narrowed it down to that investigation, including CPD and the town's investigation of Sean Goode.
All communications between Sergeant Sean Goode on one hand and Michael Proctor, Kevin Albert, Brian Albert, Nicole Albert, Chris Albert, Julie Albert, Colin Albert, Brian Higgins, Jennifer McCabe, Matthew McCabe, Allison McCabe, or Carrie Roberts on the other, on the other hand, from January 28th, 2022 to present. I mean, it's limited as to time from the time of the crime. So why not? I don't know if that's overbroad either. I don't know if they have all of that in their possession. They might not have Sean Goode's communications, but they could have his work phone, his work emails and stuff like that. That's appropriate. So, okay. Let's go to the town of Canton's response to the request from Karen Reed. And then we'll go to Reed's response. When this goes to court, we will cover that hearing. I don't know if it will be contemporaneous or a day or two later. I don't expect the judge to rule at that hearing, so we will cover it. The timeliness of such is just going to depend on how much it coincides with other things and if it moves. So we'll just have to wait and see. All right. Town of Canton's opposition to Defendant Karen Reed's motion to compel the Town of Canton to produce documents pursuant to non-party subpoena. Canton objects. As relayed in the town's initial objection to the defendant's subpoena, the defendant's subpoena is overly broad, not reasonably limited in time or scope, is not reasonably tailored to produce discoverable information, seeks records and information that are wholly irrelevant to the underlying claim. Boilerplate. These are boilerplate objections. Great. Factual background. As acknowledged in the defendant's motion, the defendant previously issued a subpoena to the town and numerous other non-party entities in July 2025. The town produced numerous records in response to that extensive request. Months later, however, in late November 2025, the defendant began contacting the town and the town council seeking new records related to Sergeant Sean Goode being placed on administrative leave by the town. Well, that's why they're seeking it from the town. The town placed Sergeant Goode on paid administrative leave in late October of 2025 and coordinated with town council to retain an independent third-party investigator. That's interesting. To conduct an internal affairs investigation on behalf of the town. Okay, but they can't necessarily go to the third-party investigator and ask for the documents because the third-party investigator is going to say, just go ask the town. So they have to go ask the town. On or about December 5th, 2025, town council and defendant's counsel spoke via telephone regarding the administrative leave and pending investigation. Town council advised defendant's counsel that the only document which town council was aware that would be responsive to defendant's counsel request was a letter placing Goode on administrative leave. On or about December 12th, 2026, town council produced to defendant's counsel a copy of the notice of the placement on paid administrative leave. Well, that answers that question, doesn't it? It's what we suspected. Sorry, I'm just responding real quick. Thank you, chat. All right. So paid leave. They responded with the letter. And then they're going from there. Defendant's counsel then proceeded to send a barrage. Oh no! The emails! Too many emails! A barrage! We've been barraged by emails. Defendant's counsel then proceeded to send a barrage of emails to town council demanding attestations and declarations of whether other documents may or may not exist. Let's continue on. Barrage of emails. They wanted us to say that there was nothing else. Yeah, they did. Defendant's counsel then proceeded. I'm repeating myself. As was relayed to defendant's counsel at onset, the investigation regarding Sergeant Goode has been ongoing, and while the town is not directly conducting the internal affairs investigation, Records are generated and produced as the investigation develops. Discovery is an ongoing obligation. Isn't that your favorite? Discovery is an ongoing obligation. The defendant's assertion that town relayed that it did not possess responsive records, but now months later, the town acknowledges it does have documents is deliberately misleading and offensive. Oh, it's going to be like this then. It's going to be like this then. It's going to be like that then. Let's see. They say it's offensive, chat. Okay, well, chat's going to fill in what they find offensive. The difficulty getting discovery is just the place to start. It's going to require some creativity. The offensive, it's offensive. That's offensive. The fact that they are saying that it's misleading. Okay, look. Here's how I read that. We didn't have the documents because the investigation hadn't started yet. And once the investigation started, we started getting documents. So it might also be true that they didn't have documents at the beginning and now have documents. But it's also disingenuous to slice that with, but we don't have any documents. If you know the documents are coming, if you know an investigation is ongoing and that you will have documents, is it 100% true to say, well, we don't have documents right now? It's true, but it leaves out context that narrows the scope. Because you know that they're going to be coming, right? They could have just said deliberately misleading. They could have said it too finely parses the matter, but no. The town of Canton is like, it's offensive. That's offensive. Okay, Canton. This is what's offensive. Okay, Canton. Deep breath. Deep breath. The town and its council operated in good faith to produce the limited responsive records it had in its possession. Excuse me, can I fix that for you? Can I fix it? Let me fix that for you. The limited responsive records it had in its possession at that time. There, we fixed it. However, as the investigation developed, the concerning timing of Sean Goode's administrative leave letter appearing online and defendant's counsel's improper attestation demands necessitated more formal objections to the defendant's request for investigative materials. You guys, the public knew about the letter because it ended up on the internet. Oh no. Am I overreading this, or are they insinuating that defense counsel leaked the letter online? Is there another fair interpretation of that? The concerning timing of Sergeant Goode's administrative leave letter appearing online, is that what they're trying to insinuate? Or am I overstating it? You let me know what you think. Because it seems to me that they are insinuating that defense counsel is somehow involved. A lot of you are reading it the same way I do. Thank you for everybody that's like, Emily, I think you are reading that correctly. Thank you. I think that's what they're insinuating. I don't know if that insinuation is accurate or not, but I think that's what they're insinuating. Good. We continue to read that correctly. Wonderful. Consequently, town council engaged in several discussions and email communications with defendant's counsel in which the town expressly objected to the defendant's attempt to expand, embiggen, its July 2025 subpoena and asserted that the newly sought materials were not responsive to that subpoena. Defense counsel agreed with the town's position and issued a new subpoena to the town on February 10th, 2026. Prior to the issuance of the new subpoena, counsel for the town and defendant engaged in discussion to narrow the scope of the requested materials so to not hinder or impact the ongoing Sergeant Goode internal affairs investigation. They go on to say, in a flagrant contravention of those discussions, however, the defendant's February 10th, 2026 subpoena sought exceedingly broad records. Oh, they were disinclined to acquiesce to your request, just like you were disinclined to acquiesce to their request for an attestation? We're there now. We live here now. Flagrant contravention. That would actually be a fun band name. Make a note. Flagrant contravention. Now playing the side stage at Coachella, which is actually a really timely joke, but that also comes from the Kevin and Bean show from a million years ago when there were funny things. They would just be like playing the side stage at Coachella. It was an ongoing joke for years and years and years, but growing up in Los Angeles, flagrant contravention. Yeah, now playing the side stage at Coachella. I guess moving to Nashville, there are so many venues that we could just pick a different one each time, now playing at Brooklyn Bowl. Say Something said opening for clandestine chemistry, 100%. 100%. The closer on that lineup is Hostile Witness. Flagrant contravention opening, then clandestine chemistry, then Hostile Witness. Alexis, it's not your fault. Alexis says, oh no, I misheard that or misunderstood that as flagrant contraception. It's fair. It's fair. It's fair. Flagrant contravention. Though flagrant contraception is also funny. Either might work. They go on to say that the subpoena is overbroad, seeking all documents, videos, audio recordings, communications, including but not limited to emails, text messages, and other forms of instant messages concerning any disciplinary investigation into Sean Goode. It's narrowed by the investigation. Anything regarding to the misconduct, anything regarding the investigation into the misconduct. They say it's overbroad. We looked at the subpoena. The court's going to get to decide that. The town issued objections to defendant's overly broad and improper subpoena on February 10th, 2025. More than a month later, the defendant served town with this motion. Okay. Argument. The defendant's subpoena is impermissibly broad and seeks irrelevant materials. The defendant's motion suggests that it is simply seeking records regarding the current internal affairs investigation regarding Sergeant Goode. As detailed above, however, the subpoena in no way limits itself exclusively to the current investigation and seeks records for all documents concerning any disciplinary investigation of Sergeant Goode. Oh. So are you indicating that there might be multiple investigations? I suppose that investigations from 15 years ago, if they exist, would not be proper. But would this need to be limited? Are we arguing this because there's something responsive, or are we arguing to delay? I don't know here what the answer is. There might be no other investigations and they might be arguing to delay. But if they are limiting to investigation relating, I guess they're asking to narrow the scope to disciplinary investigation of Sergeant Sean Goode relating to his suspension in 2025 is maybe the language that they would prefer. But it's civil discovery. You're allowed to cast a wider net, and then the court narrows down what can be used afterward. They go on to say it seeks all communications surrounding any report or alleged misconduct of Sergeant Goode and communications between Sergeant Goode and more than half a dozen non-town employees for more than 4 years. I mean, if those conversations are on his work phone or work computer, then yeah. If he's using work methods to communicate, then yeah, those should be produced. It doesn't matter that they're more than 4 years. Such requests are exceedingly broad and unduly burdensome upon the town and seem directly tailored to try to obtain attorney-client communications. Huh? Whose attorney-client communications? Okay. They seem directly tailored to try to obtain attorney-client communications and or attorney work product materials regarding the current investigation. I think that's a little bit of a stretch. The defendant's motion makes no attempt or sufficiently establishes the need for such miscellaneous records not related to the current Sergeant Goode investigation or the town's internal communications and other documents regarding appointing an independent investigator. They go on to say that even if arguendo, we love a use of arguendo, even if arguendo, the defendant's subpoena was limited to only materials regarding the ongoing internal affairs investigation, the town fails to see how any such records are even remotely relevant. No, seriously. Are we just, like, for real? Are you being for real though? Because like, you're not perceiving the situation correctly if this is so for real. The town fails to see how any such records are even remotely relevant to the allegations and defenses in the instant action. Girl. Okay, I disagree. I disagree strongly. Disagree. They go on to say the defendant's motion fails to articulate any relevancy whatsoever. It simply insists that Sean Goode was one of the initial responding officers to Mr. O'Keefe's tragic death on January 29th, 2022, that Sergeant Goode and Michael Proctor are, quote, close longtime buddies, and merely concludes somehow that, quote, documents related to the town's investigation into Goode are relevant to the claims and defenses in this action and discoverable. However, the current investigation, which did not even begin until nearly 4 years after Mr. O'Keefe's death, does not involve any allegations remotely related to Mr. O'Keefe's death. You're really trying to split hairs on that one, though. Because if it's related to Proctor, then it's related. And if it's not related, then it won't come in. But they have the right to get to that information. Okay? They go on to say that it does not involve any allegations remotely related to Mr. O'Keefe's death, the defendant, and or Goode's involvement with the investigation surrounding Mr. O'Keefe's death. They can't know that without seeing it, though, because I don't think they can trust, at this point, the assertion that the investigation into Sergeant Goode does not involve the perhaps fallout from the Karen Reed trials. They can't know that without seeing it. Any records in the town's possession regarding the current investigation are irrelevant to the instant action, and the defendant fails to articulate any relevancy or need for such records. Anna said, I'm confused. Anna, you're not confused. They're confused. You're correct. Goode was a witness for the Commonwealth in both trials. How can they now say his text messages with Proctor are not relevant? Uh-huh. You're not confused. You're right. I think, how are they arguing this? Correct. Don't doubt yourself. At this point, if you're going to press X to doubt, do not doubt you. You are reading the situation correctly, chat. Canton, however, X'd it out. Which is why the arguments aren't landing, because you're like, I just don't believe you. Like,
all of the good faith has just been burned to the ground based on the things that keep coming out in this case and others. So I just don't believe you. I don't believe you when you're arguing that this has nothing to do with John O'Keefe's death. It has to do with the connection between Goode and Proctor. Proctor's the lead investigator. And after all the shit that we've seen, I don't believe you that those two things aren't related. So they're just going to need to see it. And then if it truly is not related, then there's a process for the court to keep it from coming in at the civil case. And then everyone can make their arguments to keep it out later. It is premature to make the argument to not let anyone else see it. I mean, they're doing their job, but I just can't believe that that's true. That's where I'm at. The good faith has long since sailed. The more and more and more comes out about this case and others. They go on to say that the defense subpoenas would negatively impact an ongoing investigation. How? And seeks records that are obtainable through other means or already in the defendant's possession. Tell me how. Tell me how. Enlighten me. Illuminate the situation then. The internal affairs investigation regarding Sergeant Goode is still ongoing and is not concluded. Obviously. The defendant's subpoena seeks all documents in the town's possession regarding the investigation and internal communications record. Some of those might get limited. If the internal communications are between, like, the attorney for the town of Canton and the town of Canton, that won't get turned over. That is privileged, but then they need to object, identify what it is, and then assert the privilege. Because the town of Canton might be communicating with their lawyers about this. That would be privileged, but that's not going to be everything. Sure. They say, amongst other irrelevant materials, the disclosure of which could have serious ramifications and impacts on the investigation. How? If investigation materials and internal communications were disseminated to potential witnesses or Goode himself, it could prejudice or otherwise complicate the pending interviews. Do you think that Karen Reed's attorneys want to give Sergeant Goode any leg up in any of this? They're not trying to help. And do you know what would fix that? A protective order. A protective order. A protective order would just fix that. This concern is particularly apparent as records already produced to the defendant were then immediately posted online on various social media accounts. Oh, they were insinuating that, and now they just said it out loud. They do think that the letter regarding Goode was leaked by the defense. However, if it's not under a protective order, is it a leak? Because not all the discovery in the civil case is under a protective order. At the close of the investigation, the town anticipates having an investigatory report or summary. I mean, I would hope you have more than a fucking summary. And or summary regarding the investigator's findings and conclusions. As is asserted by the defendants, barring any statutory exemptions, that report would generally be considered a public record and readily accessible to the defendant via a public records request. I don't know if anybody trusts that this report is going to get done in sufficient time that it can be FOIA'd. And a lot of you are saying that the letter regarding Goode also could be responsive to FOIAs. Absolutely could be. Absolutely could be. Fair. But they really did say do a public records request. We're not going to give it to you. But that doesn't get you all the things running up to now. It goes on to say
As it asserted by the defendant, barring any statutory exemptions, that report would generally be considered a public record. Okay, defendant has not articulated any grounds for the immediate necessity of, well, I bet they're going to, of those records, or why the defendant receive investigation reports prior to the conclusion of the investigation or the drafting of any investigative report or summary. In lieu of a compelled subpoena, the defendant can simply send a public records request upon the conclusion of the investigation. They're like, just wait for it. Wait for it. Yep, wait for it. Back to Hamilton. Wait for it. Does anyone trust that Canton's going to get this done in time for them to FOIA it prior to needing to depose Sean Goode and prior to the close of discovery? Discovery has a clock. Discovery closes. I wouldn't have any faith that Canton's going to miraculously have this done before the close of discovery in this case. No, I wouldn't. In fact, I would be concerned that they would be like, oh, take your time. We don't want that report date 30 days after discovery closes. Right. I would think the same thing too. Especially seeing what we've already seen. All right. We needed more lippy. This is you guys were asking me about this yesterday, and it is the Fresh in Plum. It's like a chapstick, tinted chapstick. This one's great. Very much like the plum color. So that's what that is. For all of you asking. I will try to pin it down below so it's easier to find, but that's what it is. We don't gatekeep, we're just ADHD and sometimes forget. So they go on to say that it appears that the majority of the information sought by the defendant has already been obtained by the defendant. How do you know that, though? The basis of the pending investigation involves text communications involving multiple individuals, including Sergeant Goode. Those text communications are at the heart of several other pending matters and are subject to protective order. The defendant's motion appears to assert that the defendant has already obtained those text communications as newly received documents from the Norfolk District Attorney's Office. No, I think that only goes to Proctor's phone. Also, in this case, if in any case, what text messages still exist on Proctor's phone or anyone in the house's phone and what's on Goode's phone might not all be the same. Have we not learned by now that the delete your shit in all of this is strong? They need both sides of all the conversations to see what, if anything, was deleted and how much was deleted. It's a huge factor in this case. And the body of the text messages aren't in the carrier records. So even if the carrier records let you see that there were texts that were deleted, you need both sides to try to get to all of those text messages. We saw that in the Kouri Richins case. We've seen that in this case over and over and over again, that things just whoopsie doodled. So, yeah. Exactly. I want to read that as Sarah because my brain sees that there's a letter in between and I can't read it. Either way. Or sarcasmical. I don't know. I'm behind, but we need a read Troy. That's offensive. Button. We might need read Troy's. That's offensive. We might need it. It doesn't come up that much, but in this motion, because sometimes when we're talking about stuff being offensive, we're aghast. Here, we're just like, oh no. Woe is me. Woe is me. Freaking Canton, man. So they're saying you already have it, you can FOIA it, and it's not ready yet.
In lieu of a compelled subpoena, the defendant can simply send a public records request upon the conclusion of the investigation. They think that the defendant's already obtained these things. Those are only as to Proctor, though. The basis of the pending investigation involves text communications involving multiple individuals, including Sean Goode. Those text communications are at the heart of several other pending matters and are subject to a protective order. They can still be subject to protective order. The defendant's motion appears to assert that the defendant has already obtained these text communications as, quote, newly received documents from Norfolk District Attorney's Office. If there was a download from Sean Goode's phone, I highly doubt that they have it. They have the stuff from Proctor's phone, but you are entitled to both sides of that conversation. Thus, the town's investigation into these text communications seems irrelevant. Oh, vibes. How did we get to vibes? Your Honor, it just seems irrelevant and immaterial. Vibes. Conclusion. This is not the first subpoena the defendant has issued to the town in this action. Well, right. And then you told them the other one didn't cover it and to go fucking pound sand. So they wrote a new subpoena because you said, we're not going to do it under that one. Oh my God. The circularness. We're back into a tornado of bullshit. Well, Your Honor, they already subpoenaed us. Yeah. And they said, well, you turn this over under the subpoena. And you said, no. Good luck, subpoena it again. They subpoenaed it again. And your argument is, but Your Honor, they already subpoenaed us. Get out. Just. Y'all, since we're talking about the tornado of bullshit, I think we can say that this argument is in fact plumb wild. It's a plumb wild argument to make. They already subpoenaed us. Stop it. They go on to say that the town, through its counsel, has engaged in continuous good faith discussions. With the defense counsel to avoid motion practice and discovery disputes for a claim in which the town is not a party. Yet. The defendant's barrage of demands for irrelevant town records during the pendency of an internal investigation started years after the death of John O'Keefe, however, has necessitated the town's objection. Your Honor, they made us object. They want us to mention it all. We don't want to mention it all, Your Honor. We must object. Heavens. Okay. They go on to say the defendant's February 10th subpoena and repeated demands for pending investigation materials are improper, seek irrelevant records, and was issued in bad faith due to the defendant already having possession of the underlying text communications. Lord, I don't think they do. They are entitled to both sides of the text communications. I've said it. I'm not going to say it again. I stand by what I said. The town has already responded to the extremely extensive subpoena issued by the defendant in July. Well, it wasn't extensive enough to cover this, was it? Because you told them to issue a new subpoena and then they did. And you went, not another subpoena. Stop it. Extremely extensive subpoena. And there has to be some logical and appropriate restrictions upon the defendant's continual demands for records from the town. The town maintains that disseminating internal affairs investigation materials at this time is improper and harmful to the pending investigation. I don't think it's harmful to the pending investigation if it's under a protective order. The defendant's subpoena is overly broad and is moot, given the records already obtained. The court must therefore deny the motion to compel, or at the very least, significantly narrow and limit its scope. Any such responsive records are issued under seal or protective order. I agree with that part. Look, we found one. I agree with that part. I think issuing it under seal or protective order is appropriate if it's an ongoing investigation. Not everything should be, but I think some seal or protective order is appropriate. Fine. Let's see what the defense had to say as we tee this up before it goes to hearing, well, early next month. I guess we're already almost at the end of April. It feels like. Emily, it's the 16th, girl. We're in the middle. I know. We're going to keep reading because there is a surreply from defendant Karen Reed that was filed April 8th. Look at us. We're somewhat timely. We've been behind catching up on all of this, and we are somewhat timely. D. Marie, you asked a great question. D. Marie in the chat said, who's paying for all these motions? The O'Keefe family or the town? I missed the beginning. It doesn't matter that you missed the beginning because we didn't talk about it. The town of Canton is a non-party. The town of Canton has to deal with the litigation on their own. So this is through Canton's attorney. This is not the O'Keefe parties asking for this. The Reed parties are subpoenaing a non-party. So Canton's not a party to this action. They're using a non-party subpoena. The obligations between the parties are different and handled by the parties. So this is the town that has to pay for all this. I mean, they've got the city attorney is, I imagine, just a salaried employee and not an outside firm, but one never knows. It might be an outside firm. So yeah, Canton's doing the things, right? Let's take a look at the response to this. This is before Canton gets sued, right? Because in other motions, we have seen Reed's attorneys and other attorneys indicate that they are going to also sue Canton. Canton has just not gotten sued yet. This, again, the filing stamp up at the top from April 8th. Defendant Karen Reed's reply. Oh, there we go. It really bugs me when it's formatted ugly. Defendant Karen Reed's reply in support of a motion to compel the town of Canton to produce documents pursuant to a non-party subpoena. Your Honor, give us the discovery. It's not going to burden the town. Summary of the first sentence. As the court knows, Reed was tried for and acquitted of the murder of John O'Keefe III. She argued in her criminal defense that she was framed and that the investigation was corrupt, biased, and otherwise tainted. Plaintiffs are now suing Reed for wrongful death. I just fucked up the formatting again by not leaving well enough alone. Sometimes, Emily, you can over-knead the dough. All right, leaving it alone. The first participants in that investigation were members of Canton PD, CPD. The CPD officer who received the 911 call concerning John O'Keefe was Sergeant Sean Goode, who then responded. He testified at Karen's trial. I'm kind of summarizing this because we've seen it a couple times now, and I wanted to get to what, if anything, is new. Reed's subpoena to the town seeks disciplinary records relating to Sergeant Goode, including documents gathered as part of CPD's investigation of Sergeant Goode's troubling communications with former State Trooper Michael Proctor, who was the lead detective of the O'Keefe investigation and arrested Reed. Right. As we've said. Indeed, CPD's investigation into Goode came in the aftermath of a jury finding Reed innocent of all charges relating to O'Keefe's death and the discovery of thousands of messages on Proctor's phone, including many to and from Goode. Goode and Proctor have been close friends for over a decade and were or are part of a small group chat in which they shared messages with the words are hard, messages with each other about various topics. Was one of those topics this case in Karen Reed? I bet it was. Maybe it's not, and I'm open to being surprised. I'm just not expecting it. The disciplinary history of one of the first officers on scene and his relationship with the lead detective on the case are directly relevant to the nature and reliability of the investigation, which is at the core of a number of plaintiffs' claims. As a result, the documents are well within the scope of discovery. Also, Canton was conflicted out. If Goode is continuing to have conversations with Proctor, a jury might be more readily able to find that that tainted the investigation because it gives them a boundary. They were conflicted out. They were out of this investigation. And yet one of the first responding officers is still talking to the lead agent. If that was happening, it's very relevant to a jury in the assertion and defense of this case that the investigation was biased from the beginning. Obviously. Because a jury might sit there and be like, I have a really hard time with this overarching conspiracy. It's much easier for my brain to process that there is so much bias and that the interrelationships are so intertwined that they didn't even need to come to a conspiratorial agreement because it was so woven into the way they operate that they just have each other's back, that it was just part of the bias, that they all just had each other's back. They didn't have an express or explicit conversation because it was known, I got you. They didn't need to have a deeper conversation. It was just understood. And that might be easier for a jury to wrap their head around, the understanding of, I got you, if they see the text messages, and the text messages go to bias. And it would be easier, particularly for like an analytical juror, to take a look at, hey, they were conflicted out and they're still crossing that boundary to have a conversation. That's something that you can point to that is grounded and factually based, that at this day, Canton was supposed to not be involved. If Sergeant Sean Goode is still having conversations with the lead investigator, it's really, really firmly rooted that behavior was happening that shouldn't have been happening. And that is easier for a lot of people to wrap their head around than a wide-ranging conspiracy where people are having explicit conversations agreeing to be nefarious. But it helps people understand, or it could help a jury understand, that everyone is so intertwined that there didn't even need to be a conversation because I got you. She's the one that's outside of this tight-knit community of not just Canton residents, not just people that went to high school together, but also law enforcement officers. And if you have people communicating across a hard professional stop of our entire police department has been conflicted out of this, it's much easier to show, look, this tangentially relates to bias. Though I think a local jury is going to understand small town shit without having to go beyond the, look, they all knew that it wasn't going to be a problem. When they might argue that when Goode knew that Proctor was going to be the lead investigator, then he's like, good. Then it's good. Literally. So it seems that none of the law enforcement officers were even asking, why aren't we talking to the people in the house more? Because everybody just understood why they weren't. They didn't need to expressly state it. They just all knew. Okay. Fine. But when you have those things that are tangential, it helps a juror who might come in being like, I question everything, see these points of professional lapses and have them more tangential, or what word am I looking for? But have them easier to grasp because they're so clear. And then it becomes less, ethereal that there was this kind of understanding. It becomes more grounded and much more tangible
Thank you, chat. Tangible is what we were looking for. It becomes much more tangible to see you were conflicted out of the case and now you're ongoing communications. I can see exactly why they want these communications, and I can see why that might help a jury. Because a lot of people are going to look at this and be like, okay, so everyone's having this conversation that they're all just agreeing to do this thing. Well, maybe they're not saying the quiet part out loud. But it seems that not one officer is like, hey, maybe we should go in the house. Nobody even asked. Nobody even asked. Shouldn't we go in the house? Shouldn't we separate these witnesses? Shouldn't we talk to them at the police department? Shouldn't these be recorded interviews? Shouldn't they be interviewed separately? Shouldn't we find out if John O'Keefe went into the house or not? Shouldn't we go just look? Shouldn't we ask? Nobody seemed to ask those questions. And maybe this is why. And they're allowed to argue that. So, of course, they're asking for the investigation and the messages. They go on to say that the disciplinary history of one of the first officers on scene and his relationship with the lead detective on the case are directly relevant to the nature and reliability of the investigation, which is at the core of a number of plaintiffs' claims. As a result, these documents are well within the scope of discovery. They go on to say that the town's only other basis for opposing Reed's motion is that the CPD investigation of Sergeant Goode is ongoing. The town claims that this private employment matter, allows it to disregard a legally issued subpoena and refuse to produce documents until the town decides that an investigation is complete, thereby controlling the timing of its own discovery obligations. Oh, look. Weren't we just? We're all on the same page then. Controlling the timing. Do you think they would be done with this investigation prior to discovery being closed or nah? I'm leaning towards nah. Thereby controlling the timing of its own discovery obligations without regard to Reed's rights or the court's case schedule. The town does not cite a single case supporting this proposition or any other proposition. On the other hand, Reed's memorandum of law in support of her motion cites multiple cases that contradicts the town's position. Reed will not reiterate her earlier explanation here. The town may not withhold these documents based on the status of its own internal investigation. Finally, all of the cats were in the office today, and now there's fuzz. There's fuzz. Finally, the town's opposition contains a number of mischaracterizations of the parties' conversations and Reed's attempts to comply with Rule 9C. Attached as Exhibit 1 are 2 email chains that reflect those attempts. Oh boy. Oh boy. Thank you, counsel, for attaching the emails. Do we always want to see the emails? Yeah, we fucking do. We always want to see the emails. Not just 2 emails, 2 email chains that reflect those attempts. Reed will not rehash them in full here. Don't worry, we'll go read them. However, it is particularly disingenuous for the town to suggest, without any evidence whatsoever, that Reed would immediately provide documents relating to Goode's investigation to the media. That's offensive. As the town knows, and as is reflected in Exhibit 1, Reed agreed to consider confidentiality restrictions on those documents while the investigation was pending to allay the town's concerns. Right. Exhibit 1, February 10th, 2026, 10:10 a.m. email. Despite initially indicating interest in this proposal, the town elected to instead ignore it, object to producing any documents under any circumstance, then suggest to the court that the offer never existed. In any event, there is no legal basis for the town's position. Oh boy. Well, Exhibit 1, chat.
Receipts, proof, timeline, screenshots, in everything.
It's time. Okay, here's where we're at, chat. It's time to get into the emails. I didn't know there were emails. I'm so excited that there's emails. Emily, you don't pre-read the motions. Obviously, I would plan my time better if I did. No, I don't. If I have pre-read something and I'm going to summarize it for you, I will always tell you, I prefer that we all get to discover things together, which is why we have such no spoiler rules in the chat, because I just want to see what's coming as it happens. I need to stand up. We need to stand up. I am very wiggly today. My back is bugging me. And so we're going to stand up. I'm going to put on our hold music for just the briefest of moments while I move the chair and put us into, we need to transform into EDB stand mode for these emails. Are you ready? I need to stand up. We need to stretch. It's time. It's time to stand up. So we've got our hold music for what? Less than a minute so we can stand up. Let's go. All right, chat. I think the desk is at the right height. We'll see. Optimistic. Are we ready? All right. We feel like we're in the right spot, so we're in the right spot. We needed to be in stand mode. Stand mode activated. I love that chat was like, all rise. Yes, all rise for the stand desk. All rise for the stand desk as we get into the receipts, proof, screenshots, timeline, fucking everything. And if you do not know what that clip is from, it is from the Real Housewives of Salt Lake City from 2 seasons ago. It's from one of the final episodes of that season. I think it was 2 seasons ago, 1 season ago, but it was from Real Housewives of Salt Lake City with a fallout over whether or not somebody on the show was also running accounts regarding the show, et cetera, et cetera. So let's continue with the, well,
Receipts, proof, timeline, screenshots, in everything.
fucking everything. Receipts, proof, timeline, screenshots, fucking everything. Let's go into the emails. This is from, for those of you just coming in, we are reading Karen Reed's reply to Canton's opposition in their fight for discovery, filed April 8th, 2026. So let's continue on. Friday, February 20th, 2026, 4:30 p.m. Wait, are these going to go? That's Wednesday, February 11th. Oh, we're going to have to start from the bottom now. We're here. Okay. We got to go read the email thread starting from the bottom. That's March. Okay. We got to start at the bottom of the email thread and work our way up, or it's going to get very confusing very, very fast. Let's see. January 30th, 2026, 3:59 p.m. from David to Aaron.
We're going to go with that. It'll keep it easy. Hello, Attorney Aaron, by last name Rosenberg. I'm emailing to follow up with your previous correspondence with Attorney Kenny from my office and your request for additional records related to the subpoena issued to the town of Canton on or about July 22nd, 2025. I was hoping to set up a call for us to briefly discuss the matter. Do you have some availability next Thursday or Friday afternoon for a conference call? All right. The response there at 4:03 p.m. same day, January 30th. Yes, I'm available Thursday at 2 p.m. or 4 p.m. and Friday anytime after 1 p.m. And then Aaron followed up on February 2nd. When are we speaking this week? So it looked like they hadn't solidified that. Let's see. So January 30th, we get to February 2nd with no response of Thursday, Friday. When are we talking? That was me typing, by the way. February 10th. Girl, you ask to have a conversation on the 30th. Then you respond, do you have some availability next Thursday or Friday? Oh, okay. Well, maybe it was the next week and it was misread as to this week. Maybe that's where the disagreement was over the new year. Let's see. Are we speaking this week? February 10th, David, Chris, thanks for the time last week. Oh, they did speak. Okay, thanks for the time last week. As we discussed, attached is a second, more discreet subpoena, specifically relating to the investigation into Sergeant Goode, any misconduct and communications between Goode and the relevant individuals in our case. Please confirm that you accept service of this subpoena on behalf of the town of Canton, Canton Police Department. During our call last week, look, this is exactly what you should do. During our call last week, you just take the call and conform it into writing. During our call last week, I explained that I had given the town the benefit of the doubt when Jamie told me that the town, including its council, did not possess further documents that would be responsive to requests like this. It sounds like the town may now possess at least some such documents, and they need to be produced. I understand that the town has some concern about disclosing documents relevant to an active investigation. Although that is not a valid objection to a properly issued subpoena in a civil case, I am willing, as I said on the phone, to consider limited confidentiality restrictions on those documents, which would be effective until the investigation is completed. If you would like to propose such restrictions, let me know. Otherwise, please produce the documents. I mean, I summarized that last sentence, but yeah, please produce the documents. Okay. It goes on to say, February 11th, so this is the next day, from Aaron to Canton lawyers, please confirm today that you accept service of the attached subpoena. Otherwise, we will serve the department directly. There are some things that just feel so dumb and gamified, but when you are counsel of record for the city of Canton, not just responding, obviously, yes, we accept service, is so frustrating. It's just so frustrating. It goes on to say, from David responding to Aaron, February 11th, yes, as discussed, I accept service on behalf of the Canton Police Department. My office is coordinating with the department, and I will hopefully be able to follow up with you shortly regarding the subpoena. Okay, at least it's a response. This is from February 20th. David, I assume the attached email letter means that you are now refusing to provide any documents in response to this subpoena, even if we agree to confidentiality provisions. Despite our numerous attempts to confer, our offer to work with you to address your client's concerns and your colleague's prior statement to me that the documents in question do not exist. The department do not exist in the department or town's possession, custody, or control, which your letter does not assert. Please confirm that I understand your response correctly. And if so, please let me know when you are available Monday to confer pursuant to Rule 9C in advance of immediate motion to compel, as Judge Gildea, has urged us to do in this case, which we all watched the judge do, which we all watched what the judge did at that hearing where the judge was like, bring it to me. Bring it to me. Which is helpful. So let's take a look at the next email thread because they are just, okay, this is March 23rd. All right, where are we leaving off? February 20th. Great. There's no bottom of this email chain. Okay. We are now on February 20th. Enclosed, please find the Canton Police Department's objections to the subpoena regarding the above referenced matter. A physical copy has been mailed to your attention as well. I'm sorry, where's the barrage of emails? Sarah said it in the chat too. So far, this is not a barrage of contact. Yeah, these are just work emails. And I don't see, well, maybe the barrage of emails came before this. It's like, hey, we need to do the things so we can do what we need to do with the court, because we need to do what we need to do with the court. Attached is Defendant Karen Reed's motion to compel the town of Canton to produce documents pursuant to non-party subpoena and her motion of law in support. I understand from our previous phone conversations and email exchanges that you are not willing to produce any documents in response to the relevant subpoena. If I am incorrect, or if you believe further conversation pursuant to Rule 9C would be productive, please let me know and I'd be happy to schedule a time. Hey, we have an obligation to meet and confer so that we can try to work this out before we drag the court into it. Like, don't go to mom unless that you have to. Try to work it out. Are you going to turn things over? No, great, done. Then it is. And that's just what it is. So it's, they're trying to deal with it, but I understand that Canton's like, yeah, we're not going to do that. But also, I don't understand why the nonsense of just not answering. Like, what are we doing? I just don't get it. Like, they're trying to work with you for the, oh, my chat just like refreshed and went, where did it go? Okay, now it's back. I don't understand, A, where the barrage of emails is, and B, why we can't just meet and confer. Obviously, the meet and confer from the town of Canton's perspective is we're not turning it over. Fine. So where are we at? Well, we're at the town of Canton objecting to turning over the documents regarding Sergeant Goode's investigation. We covered Sergeant Goode's investigation back in, November 2025, after news of his suspension broke, and timed in the ripple effects of Trooper Proctor's phone. Remember, at that time, Trooper Proctor's lawyer had said, hey, you can try to get to it. We're not sure there's much there. He's gotten a new phone. And then the iCloud of it all was like, oh, just kidding. There's 13 years of information. Our bad. And then Proctor dropped his civil service appeal, and then his civil service appeal lawyers dropped him. And then And then this dropped regarding Sergeant Goode, seemingly connected to what was in that Proctor phone drop. And then they've been fighting over the Proctor phone drop, and now they're fighting with Canton to get the information from Sergeant Goode. But I understand why they're asking for it. In this lawsuit, where the O'Keeffes are suing Karen Read for wrongful death, her defense is A, I did not kill John O'Keefe. B, the people who could have found out who killed John O'Keefe did not do an investigation. It is part of her defenses. And the disciplinary action that seems to me to be a ripple effect from all of this, and maybe it's not. Maybe the inappropriate, or what do they call? What did they call the text messages? They didn't say inappropriate, but maybe the horrific text messages, the inappropriate text messages, the vile, that was the word they used. Maybe the vile text messages are not related to this case at all. Maybe they're not, but they have a right to see when the ripple effect seems to be directly related to Karen Read's case, because you're not getting into Proctor's personal phone if not related to this case. Proctor was terminated in relation to his duties in this case. Goode has now been suspended. He was on this case before Canton was conflicted out of this case and is close friends with Proctor, who was fired because of his behavior in this case, in part because of text messages. It all seems connected to me. And if it's not, the Read parties have the right, I think, to be able to evaluate the investigation into Goode and argue whether or not it's connected. I don't think the town of Canton gets to be the gatekeeper here. This is not a criminal case. This is a civil case. There is broader discovery, and there are mechanisms that if it's not related, the court ultimately can hear the arguments on both sides and decide to bring it in or keep it out. But everything in this case is such a fight. And I'm not surprised at this point, but I wonder if some of this is Canton also bracing for the fact that Karen Read has indicated she's going to sue Karen Read and she is going to sue MSP. We know that there are going to be and continue to be more fallout from these cases. And we've seen it. We've seen the fallout continue. So I'm not surprised that this is such a fight. And maybe it's why Proctor hasn't requested documents in this case. And for those of you that popped in here, we had the update on the docket that this hearing that was supposed to happen at the end of April got bounced until May 7th. Let me find, where did the docket go? Oh, did my docket disappear? No, my docket didn't disappear. Hold on. Let me find my docket real quick. It's on the other monitor. It logged me out again. Let's see. Give me 30 seconds to log back in to pull the docket up again, because I did not anticipate being logged out, but I believe the hearing date is May 7th. We're going to just pull that up real quick. Let's see. So the endorsement on the motion to continue was granted today. That motion to continue was filed yesterday. We're going to just pull that back up to kind of circle back. Let's see. It's just formatting is fighting with me. Good. It will make my brain glitch even more. That's perfect. We love it. Wonderful. And the document just does not want to. I have all our formatting set so well, and then we get to the Emily Fights with Technology part of the show, and here we are. All right. So this is the granted today motion to continue the hearing on the motion to compel from April 28th to, May 5th. I must have read that earlier and have completely forgotten. Wait a second. May 5th is on a Tuesday this year? Wait. How did I not realize that? I feel terrible that I didn't realize that. A Cinco de Mayo Taco Tuesday is going to be a mess. It's going to be amazing, but we're going to have to go to dinner at like 2 p.m. because it's going to be busy. I love a Cinco de Mayo Taco Tuesday. It's like Taco Tuesday XD. I love it. Mildred Caddy said May 5th is my birthday. A lot of you have May 5th birthdays. Fun fact, May 5th also Dr. B's birthday. A lot of May 5th birthdays in the chat. I love it. I love it. I love it. I love it. All right. This has been rescheduled till Cinco de Mayo at 3 p.m. This seems like a fail. I'm so upset. It actually hits a little different that the Canton attorney is now like, I'm going to be out of the country. Bye. Like, what are we doing? Bye. Sorry, Your Honor, we're not turning any of that over. It's offensive to me. I'm going to be out of the country. Bye-bye. Bye-bye, bye-bye. Oh, goodness. Oh, goodness. Okay, boo-boo. Sure. So this hearing at this time, as of recording today, we are going to expect that the hearing on the motion to compel will be held on Tuesday, May 5th. Maybe we just bring tacos and margaritas to stream and it's 3 p.m. in Massachusetts. Maybe we just be like, you know what? I'll have to talk to Dr. B. It is Dr. B's birthday. Maybe we'll just stream it on the 6th and call it good. And we'll see what discovery will be turned over with regard to Sergeant Sean Goode, because it's not looking good for him. Emily, how many good jokes are we going to make? Everyone that I can reasonably justify, and even some that I can't justify. We're going to do that. All of them. All of the jokes. It's warranted. Because I imagine that Sergeant Goode is not the only domino that's going to continue to fall in the fallout from whatever the fuck Trooper Proctor was doing on his phone. And maybe some have retired before that fallout smacks them roundly in the face. Maybe not, because you can't terminate someone that has retired. But that is rampant speculation and quandary on my end. Just a matter of curiosity. So what happens now? Well, we are going to see this case continue to be fought over discovery. There are a few other items in the civil case we haven't circled back to that we will circle back to as we start getting rulings here. So as we start getting rulings in this civil case, we will look at it. I am keeping an eye on the Proctor phone problems and on Proctor's my memory, Your Honor. Can you please grant me limited discovery? Please. Because I'm curious what's going to happen. And as we know, Karen Reed has said she is going to be suing Canton and MSP. So when Karen Reed's attorney said she was going to sue everybody, she's going to sue everybody. And we are going to continue following it. So with that, we are going to, for everyone that has peeked in midstream, hello, good to see you, and replay crew, get the Lawnerd app. Get the Lawnerd app, because in the Lawnerd app, I keep you up to date on all the things that are going on. And next week, I will be traveling for some top secret and some not so top secret stuff. And I will bring you along on that journey as much as I can in the Lawnerd app and in the Lawnerd Lounge. So make sure that you are in the app so that you can get those updates. And if there is stuff that happens next week, I might do some quick updates in the form of some YouTube shorts from my phone, because I am not bringing, it is going to hurt my heart. I'm not bringing my streaming setup with me because I am not allowed to stream where I am going. And that is a specific limitation. And I'm going to adhere to that and be present, but I will keep you updated in the app if there are things I need to update you on. Remember, there is also going to be a new podcast on Monday, so there will be a podcast for you Monday. Let's get to some questions real quick, and then I have got to bounce because I have some meetings this afternoon, and I didn't realize how long I had been talking. Me all the time, always. Me all the time, always. I didn't realize how long I've been talking, but we got through quite a few things today. Look at us. Look at us go. Well done, chat. Good job, everybody. Let's answer some questions real quick and we'll get there. We'll get there. All right. Questions. I turned that down way too much. But there we are. You can hear the weathering outside. Kristen's parrot said, what? EDB, I will tag you on my channel. Perfect of Parrot Sky mimicking you after stream. Thank you. My parrot wants to be a lawyer. I know we had talked about Parrot Sky having conversations from EDB. Hi, Sky. I can't wait. I will absolutely go check it out and make sure that we can see it. So thank you. And Tina, thank you for the gifted memberships. To everyone who gifted memberships, thank you so much. Welcome, new law nerds. Matt, it's good to see you. Matthew, Mist Cloud, it's good to see you in the chat. It helps always when people's usernames change that everyone left their icons the same. It very much helped my brain connect everything. So it's such a good way to see you guys. And it took a minute after the name changes for me as well, and for all of you as well, to kind of connect with each other. It's just changes, always difficult. Monica said, been a viewer for 5 years, member for 40 months. Welcome. And well, not welcome. Thank you for being here all of that time. And yay, 40 months. I love seeing the member badges change. So it is always wonderful to see you guys celebrating your membership anniversaries in the chat and elsewhere. Other people's procrastination. I mean, that's kind of what today feels like when it's looking at the fights over Discovery, doesn't it? Just so much of it. Let's see. We talked about the pin chats being at the bottom, and a lot of y'all were just like, hey, we don't love it either. Thank you. Casey Cat said, is it just Kouri and counsel avoiding her being sent to prison? I think the birthday is probably a part of it. I do. I think the birthday is probably a part of it. And I think some of it's like Kouri wanted her lawyer to move it. And so her lawyer's like, I'll ask. Her lawyer did a bit more than I'll ask. But yeah, I think that that's a part of it, that Kouri doesn't want that. This is purely my speculation. That Kouri doesn't want that on the birthday. I think, though, that Kouri's jail calls kind of undermine counsel's argument that counsel needs more time, doesn't it? I'm going to pull up. I promised that I would check the docket there again, so I will do that one more time real quick. Let's see. Bad Girl said, my pondered pumpkin never came home. Bad Girl Sniper, I'm so sorry. Pet loss is a very unique and different type of grief that I don't think we talk about enough. I'm so sorry. It is a hard thing to do. It is hard to be in your home without them. And so I absolutely understand. I have been there. I still feel it with my cat, who I lost after 17 years, was around longer than the boys were, and was always just like, ugh, these children. But my soul kitty still hurts. It's been a minute, but still absolutely hurts. So our ponards are a huge part of our life. So hugs. Thank you for letting us know. And I'm sorry. We love having them. It's hard losing them. However, Rhonda has some good news for us. Rhonda, still going strong, 3 years cancer-free, and here with you, Miss EDB. Well, Emily. Emily, did you just refer to yourself by initials? Yeah, sort of. Rhonda, congratulations. That's very exciting. And a lot of you guys have had really, really good news in that way. Shar, it's good to see you too. Please say happy birthday to my mom, Joan. Happy birthday, Joan. Happy 91st birthday. Still lives on her own. Sharp as a tack. Joan, amazing. Enjoy it. And happy birthday. That is a huge birthday and very exciting. Samantha said, thank you for coming to Emily's TED Talk. Yes, Emily has feelings about how platforms roll things out. I always want to understand why they do, but also, sometimes I'm like, can you just give us choice? Thanks. Do you know what I learned yesterday, you guys? Okay, can I tell you what I learned yesterday? Chat's like, Emily, we're always going to say yes. Why are you asking? So why are you asking? Well, yesterday, another creator mentioned that you could reset your Instagram algorithm. Did you know this? I did not know this. So if you go into your Instagram settings, I'm going to try to pull it up because I have no visual memory, so I cannot remember how I did it, but I have to see it so I can get there. I'm going to tell you how this was shared with me because it was so freaking cool. And I was like, no way. I had no idea. I've never even heard about this. I know so many people that use it regularly, and I would love to do this. So here's what you do. A lot of you are like, what? No way. I know. So if I've got to find where it was, if you go into your Instagram settings and activities, there is a tab, and I'm looking for, or there is a selection that I am trying to find the exact name of because there are so many things in the settings and activity that I get overwhelmed. I'm like, I don't even read what's in there because it's so much stuff, to be perfectly honest. I'm like, what is this? But if you go in there under content preferences and it says what you see, it says like favorite, content preferences, like and share counts. Under content preferences, you can go to your algorithm and you can choose what you want to see more of, or you can choose to like yeet everything. So you can choose topics and you can add topics, and you can also, listen to me, hear me out. You can add topics of what you want to see less of. And you can just type it in. What do you want to see less of on your Instagram? I know what you want to see, what you want to see less of. And you can go and pick, and it also shows you what you've seen a lot of. It then gives you a choice for sensitive content, and you can choose how much you want to see. It then gives you a choice for political content, and it then lets you choose how much you want to see. And under political content, you can select if you want to see political content from people you don't follow or not. You can toggle it off or on. Then you can also go through interested, not interested, specific words or phrases, and then you can snooze suggested posts in feed, which means you can turn off all suggested posts so that you only see posts from people that you're following. I know. Is I only want to see animals a choice? Yes. You can type it in. What do you want to see more of, or what do you want to see less of? Yeah, you can. I haven't tried to request no AI, but it's on my list of what I would request. No AI content. But you can also turn off suggested posts entirely. If you feel like you've already curated your algorithm, then you're good. But this is one of those things where you can go to specific words and phrases and block them. You can like block them from your algorithm. Like you won't see them anymore. You can go to interested or not interested and start clicking through what you want to see more or less of. And you can start to retrain. I love it. So you have a little bit more choice, but also if you have people in your life that are using Instagram and are just like, I need a little bit more control. I had no idea this existed. And I use social media more than I would even like to, but I cannot wait to be able to also let my kiddos know, hey, you can just see who you follow and turn off all suggested posts in your algorithm. I think that's pretty cool. And I'm wondering if we will see YouTube start to do something similar, because that's how the conversation kind of came up. Because YouTube now allows you to turn off, and I haven't figured it out yet. YouTube has allowed you to turn off not seeing shorts. And I think that's pretty cool too, where you can turn off shorts entirely. And that I love. So Stromania, no one's deleting your chats. you probably need to refresh your YouTube chat, but chat has had a problem where things get typed in and disappear before you can even send it. That's a platform problem, but no one's deleting your chats. Just wanted to let you know, no one's deleting your chats. That is a YouTube problem. I need to go look. Rando, I would Google. I do not know how to turn it off, but you can turn off shorts 100%. It just rolled out. I haven't even gone to play with it yet. So there is, for all the times I talk about like the things that frustrate me, I'm really excited about the things that give us a little bit more control and a little bit more choice. And so I appreciate that as Instagram is rolling out some more algorithmic choice, I think we will start to see some other algorithmic choices where you have more control about what you can turn off or turn on. And I would love to be able to see it by device, because I know that if I'm on YouTube on my phone, it populates a lot more shorts for me that I don't necessarily want to see. Or if I'm on the computer, it doesn't offer as many shorts. So sometimes those algorithms are by device, and it's really nice to be able to have a little bit more control. And it's rolled in to the rollout on Instagram. I hope that we will see some of those rollouts on YouTube, but YouTube is rolling out. And again, when YouTube rolls things out, it will be available on some accounts sooner than others. And sometimes that goes by where you are viewing from, but YouTube has started to roll out being able to turn off the shorts feed on your YouTube. So take a look for that and see if it's available for you. Enjoy exploring, taking back a little bit more control on your IG. I don't know if this is going to roll out or something similar on TikTok and elsewhere, but I love seeing where we have a little bit more control and you can choose what you want to see and when you want to see and how you want to do that. And I love having a little bit more choice. And that's something that I've really advocated for on YouTube, as we talked about earlier today with thank you for coming to EDB's TED Talk, which is how my brain got all the way back around to, did you know that you can control some of your algorithm? Which is great. So I love it. So with all of that, Buffy, this is a great idea. Can you make this IG part into a short so I can follow the directions? Yes. I'll do some screenshots of it because trying to do it live on my phone is really hard because my phone's not connected to my stream. But I can do a post with the screenshots so you guys can see it. Yeah, I will. And I think it's great. So hopefully the choice is helpful. Lawnards, if I did not get to your question, apologies, but also thank you for being here. Thank you for being a Lawnard. Don't forget to get the app. Take care of each other. Take care of yourselves. I will be in touch. I do use Instagram. I will be in touch in the app. I will not be streaming next week. If you have not watched the supercut of Sarah Boone, you now have a week to catch up. If there's another trial that you have not caught up on this channel and you just found EDB, there is plenty of you to catch up on in the next week. And those are the places I'll keep you posted. And there will be a podcast on Monday. So if wild stuff is happening, we'll catch up with it there. And then I wanted to end with Demon Pig 89. This is a very, very kind super chat. Thank you. It's not random. It's beautiful. And shared that this is random, but your coverage of the Depp Heard trial brought me and my mother together before she died. Thank you. And I brought it up last because I knew it would make me all emo because it's why I built this community. And the stories that you all are generous enough to share with me and kind enough to share with me about this community and about what we do here is why we do what we do. It's why we do what we do. And I appreciate you so much for sharing it because it's not always easy to share. And so for all of you that have connected with friends, coworkers, old friends, new friends, family members, all across the globe in the chat, that's why we're here. And we're going to keep being here. A little bit of a pause next week. Just a little bit of a pause next week because I got to go do in-life things. However, the stories for members only will be amazing. You guys have triggered my mother because now she's calling me. Mom, I'm still streaming. I'm almost done. All right. I'm going to go answer that call. Lawnards, you're the best. You truly are.
Thank you for being here. You are what makes this channel so special. This community is incredibly special, and I love seeing all of you day in, day out, trial in, trial out. It's a joy. All right, I'll see you soon. Take care of each other. Law nerds, stay hydrated, because I'm not going to be here to remind you as much next week. Stay hydrated. Take care of yourself. Be kind to yourself. I will see you soon. Bye. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android, so I can keep you in the loop, because you never know when something's going to pop off. Thanks for being here, and thanks for being a Law Nerd.